cancel this one.
Alright, well, I'll monitor you anyway.
I did this in 12 minutes in Bangkok, and my paper's half the size now. So I would be very, very surprised if I was able.
We're good. Yes.
The velvet glove
Like,
there.
we've got to get organised. And he's like, I'll go off and get the clicker for you.
He said that?
And he doesn't go and get the clicker for you. And he's like, yeah, we're going to start. I'm like, I mean, I do love him, but he's hilarious. He's an old cop. And as an old cop, we have our, different ways of approaching. Yes, we have a clicker. Thank you, Berrigan J. Male behaviour as well. You MC for the entire day?
Just temporarily while Anthony's gone to court.
Is he in front of Oh, he'll be out of it. Canning's is one of our most efficient judges.
Yes.
But he has very long lists, so you never know.
Am I all right? Oh, yes.
Just start.
It's a prayer.
He actually
Yeah.
said he would get
Okay.
me a proper coffee.
You guys are just becoming
All right, well, good morning, everyone. Just a couple of minutes before 9 o'clock. We have to run a tight ship this morning so that we make sure that we stay to schedule. My name, Justice Derek Wood. I'm standing in this morning for Mr. Anthony Roden-Paru, who's our MC, and Anthony's gone to court before Justice Canning's. So hopefully it's not a long appearance, and he'll be back as soon as he can. Before we start the first session, just like to welcome everyone again, including our Chief Justice, Sir Gibbs Salika, all the other Chief Justices, judges from around the area, around the region, all our attendees, all the LAWASIA delegates. Also this morning, a big welcome, of course, again to, it's very important that we offer training where we can. So we have a lot of young lawyers from the public service, private sector here, and of course students, including those from the University of Papua New Guinea. So it's terrific that they can be here. All right, so before we go to our first session, I'm going to ask Justice Paula Stower to come forward and give a prayer. Thank you.
Let us pray. Dear God, we thank you for this morning. It's a beautiful day. It's the day you've made. We rejoice in you and are glad in it. Dear God, we thank you. In the beginning, you created the heavens and the earth and said it was beautiful. You gave man to be stewards, to replenish and subdue. Father, this morning, in the course of time, we try to manage, at the same time grapple with development issues. And we are at this crossroads that we're trying to find our way in best managing the resources you have given us. This morning I pray for the speakers as they continue to teach and instruct and provide information that is useful for us, the stakeholders. We pray that, Lord, you'll continue to grant them wisdom, knowledge, and insight. Also, for us, those of us who are learning from it, that we'll implement what we have learned today. Those information can become useful for dispensing our duties. Father, I thank you that we'll have a blessed time today and onwards. In Jesus' most wonderful name, I pray. Amen.
All right. Chief Justice Sir Gibbs Salika, Deputy Chief Justice Ambeng Kandakazi, Chief Justices, judges, distinguished guests, ladies and gentlemen, morning Tro Olgeta, Dabai Namona, good morning and welcome. I'm Justice Teresa Berrigan. I'm a judge of the National and Supreme Courts of Papua New Guinea. And it is my enormous privilege to open this session on institutions for the environmental rule of law. As judges, as lawyers, as academics, as students, we are acutely aware that the rule of law is not some abstract, self-executing concept. It depends on institutions and on individuals prepared to give it effect every day. Across the Pacific, there is a growing sense of urgency to protect the environment. And it is the Pacific that has led these efforts on the international stage. We should expect, therefore, domestic environmental litigation in our courts to grow accordingly. And perhaps, unfortunately, as we'll hear, deliberate attempts to stifle it. And so also increasing scrutiny on the institutions meant to support that litigation. The protection of defenders, the safeguarding of lawyers from strategic suits designed to silence them, and the role of a free press, which we've really not talked about so far, in informing public debate. This session looks to that emerging landscape. Our panel brings academic and practicing experience from across the world, and their insights will be of real value as we navigate this growing area of litigation in our jurisdictions here in the Pacific. I'd like to invite our first two speakers to the podium now. They are going to tag team. Mr. Matthew Baird is the Director of the Asian Research Institute for Environmental Law, and Mr. Ronan McSweeney is the President of the Law Society of New South Wales. Both of them have many, many years of experience in this area. Matthew in Australia and Asia, Ronan in Europe and Australia. They will speak on what might be new to some of us, and that is the Luxembourg Convention for the protection and how it applies to the protection of environmental and human rights lawyers. Please make them very welcome. Thank you.
Thank you, Judge, and please acknowledge that all formalities are observed, and it's a great honour and a privilege to be here. So we have a joint team today with the President of the New South Wales Law Society, Ronan, and myself. I'm just going to set the scene, if I may. And yesterday we heard so many amazing stories of litigation and courageous lawyers. And although some speakers will talk about environmental human rights defenders in general, we're going to focus on protecting the lawyers who can also be identified as environmental human rights defenders. For many years, Global Witness has been tracking the abuses and the threats and intimidation that have been levelled against those people, environmental defenders, human rights defenders, defenders of Indigenous lands and others. And what they show is across the world, we are seeing a rise in threats and attacks on those who are seeking to protect through their work the planet that everyone has spoken of as God's gift to us. So Global Witness has identified the number of countries, in particular in Latin America and the Caribbean, in Brazil and Guatemala. We've also seen in the Philippines, in our region, is one of the most significant areas for intimidation and threats against environmental defenders. And while it is clear that a lot of the focus of these threats and intimidations are against those who are running the campaigns, who are seeking to protect their own work, the Indigenous peoples, small-scale farmers, there is a growing area, small but growing, of the lawyers who are representing those people in court or even in the campaigns that are running. I just wanted to personalise it with two cases One, a very good friend of mine, Dang Dinh Bach, a Vietnamese lawyer who for 10 years ran a policy institute, the Law and Policy of Sustainable Development Research Centre. And he, over 10 years, built that up to a 30-person institution working with NGOs, government organisations, banks and financial institutions trying to advance environmental law in Vietnam. 5 years ago, the facilities of the centre were raided by the Vietnamese police. He was charged with tax avoidance and offences, and he, along with a number of other environmental lawyers in Vietnam, including a Goldman Prize winner, were sentenced to jail. And he was sentenced to 5 years, and just on the 24th of June, which happened to be my 60th birthday, he was released to be back with his family. He was, for the last 15 years, one of my inspirational lawyers in Asia Pacific, and threaded the challenging circumstances and situation between working in a country that was not terribly supportive of public interest environmental lawyers, but he worked well with the government. But at one point he crossed the line, and the government came down and prosecuted him. Because he was charged with tax offences, again, questionable issues of financial crimes, many people said, well, this is not a real environmental defender. But the focus was on stopping his work, which was dealing with the issues of free trade and coal and climate change. The other person, again, is another inspiring lawyer from the Philippines, attorney Golly Ramos, former vice president of Oceana, a major oceans and protection organisation. She faced a SLAPP suit, and you'll hear a bit more about those type of, for 8 years. So this was a case brought against her for criminal defamation that was running for 8 years, during which time she still continued to campaign for the earth and for the oceans and the planet, before it was finally dismissed. The important thing about that is that in the Philippines, the Supreme Court of the Philippines have specific provisions to protect lawyers from SLAPP suits, but yet that did not work in this case. And so this is one of the challenges that we face. Even if we do have certain protections, including in Indonesia, where they have directives issued by the Supreme Court, or the Philippines, where they have rules of procedure, we can still find ourselves challenged and under threat. And now I hand over to President Ronan.
Thank you, Matthew, and good morning, everybody. As Matthew outlined, lawyers upholding the rule of law can be uniquely vulnerable. You can see that summation on the slide behind me. But on the 12th of March last year, the Council of Europe unanimously adopted the European Convention on the Protection of the Profession of Lawyer, or the Luxembourg Convention as it is known. It addresses a critical gap in international protection for the legal profession. Today, I want to consider what its adoption means practically for lawyers and the rule of law around the world, particularly in this region. It may prove to be an antidote to the growing threats to lawyers, particularly environmental lawyers, both in this region and globally. Before turning to the convention itself, I'll briefly mention that the Council of Europe, the author of this convention, does not form part of the European Union. The two institutions are actually separate bodies with distinct memberships and mandates. The Council of Europe has a much broader membership than the European Union, including countries like Belarusia and Kazakhstan, and indeed, until the war in Ukraine started, it included Russia. Over many decades, the Council of Europe has developed a substantial body of treaty law, most particularly the European Convention of Human Rights, but it has also developed other instruments of law that are used internationally. And many of their conventions are deliberately designed to be open to ratification to non-member states, so countries outside Europe. Most particularly, a good example would be the Cyber Crimes Convention, or what's known as the Budapest Convention, which was ratified by many countries in this region, including this country, PNG. So this can transform what might otherwise be purely a regional instrument focus mainly in Europe, into something that approaches more of a global standard. So Article 18 of the Luxembourg Convention allows for this in respect of this particular convention. And it paves the path for our respective nations in the Asia Pacific to participate and sign up to this new standard. So what rights does the Luxembourg Convention protect? The substantive provisions are set out in Chapter 2, Articles 4 to 9. They constitute the most comprehensive international framework for the protection of lawyers ever adopted. Articles 4 to 9 can be split into three themes, namely, Articles 4 and 5 are about protecting an independent, self-governing legal profession. Article 4 seeks to safeguard the independence of professional associations of lawyers. It requires that these bodies be self-governing and free from government control. Article 5 regulates entry into and continuance in the legal profession. It requires that decisions affecting a lawyer's ability to practice be based on objective, transparent criteria, free from political interference, and subject to an independent court or tribunal. Articles 6 and 7 concern freedom of lawyers to advise and represent people. Article 6 upholds the right to provide legal advice and representation to all clients, including in the defense of human rights and fundamental freedoms. Critically, it also protects the confidentiality of lawyer-client communications. Article 7 protects the right of lawyers to inform the public about their clients' cases and the freedom of expression of lawyers and their professional associations. Then Article 8 and 9 concern protecting the legal profession from abuse and attack. Article 8 itself regulates disciplinary proceedings. It requires that disciplinary action be exclusively based on professional standards of conduct prescribed by law, that disciplinary action is carried out by an independent, impartial body, and any sanction applied is proportionate. And Article 9 addresses what's referred to as protective measures. It says detained lawyers must have prompt access to a lawyer of their choice and the right to notify their professional association that they have been detained. Finally, Article 9 also requires states to ensure lawyers and professional associations are free from physical attack, threats, harassment, intimidation from state authorities and private actors. I want to briefly address, at a high level, the pros and cons of the convention. The case for the milestone is that it is a new legal benchmark. Prior to the convention, states with otherwise strong legal systems were not compelled to meet minimum standards for the protection of lawyers. The convention seeks to change that. For states that ratify it, the protections of Articles 4 to 9, which I've briefly summarized just now, become obligations in international law. Of course, incorporation into domestic law remains a separate hurdle, which will depend on each jurisdiction. However, the Convention's openness to non-member states outside Europe is genuinely significant. It has the potential to establish an international benchmark for the protection of the legal profession far beyond the Council of Europe's 46 member states. The case against this milestone instrument are its structural gaps. Arguably, one of the most significant limitations of the Convention is the lack of an enforcement mechanism by an aggrieved person, unlike, say, the European Convention of Human Rights, where individual rights can be litigated before an international court or tribunal, and this is simply not available under this convention. The convention also fails to establish an emergency response mechanism for lawyers facing imminent threats. The treatment of non-state actors is also another gap in the instrument. Finally, there is the fundamental question of political will. Treaty ratification, of course, is no guarantee of compliance. And it doesn't take a lawyer like you or I to know that a government that is willing to persecute lawyers is unlikely to be deterred by adverse reporting, nor allow investigatory visits under the Convention. So in precisely those jurisdictions where lawyers face the greatest risks, a monitoring mechanism as proposed by this Convention is likely to be least effective. Despite this, the Convention's most durable contribution may lie not in what it enforces, but in what it establishes. Today, 33 countries have signed the Convention. Entry into force requires 8 ratifications, at least 6 of which must be from Council of Europe member states. No state has yet ratified, so the coming years then will be critical. I want to close with a direct appeal to everyone in this room. The Luxembourg Convention, as I say, is open not merely to European states, but potentially to the world, including PNG. Every lawyer, every bar association, every human rights organization, every environmental organization represented here today has a role to play. I would encourage you to return to your home jurisdictions and advocate for your governments to sign up to the Convention. The more broadly it is accepted, the more legitimacy it acquires. The more quickly it sets a normative global standard for the protection of lawyers. The more legitimacy the Convention acquires, the harder it becomes for any government, no matter how powerful, to treat the protection of lawyers as an optional extra rather than a binding international obligation. And who knows, a lawyer here right now may one day benefit from that protection. Thank you.
Thank you so much, Matthew and Ronan. Building on this theme, we're now going to turn to Mr. Stephen Tiru, who we met yesterday, the President of the Commonwealth Lawyers Association. He's going to speak to us on protecting environmental defenders from SLAPs, that is, strategic lawsuits against public participation. And I just want to quote something that Stephen has said. In the absence of an independent bar that is steadfast and tenacious in its defence of universal and inherent rights, freedoms would be reduced to little more than a fleeting mirage. Please welcome Mr. Tiru.
Morning. Morning, can you hear me? Yes, it is. Yes. Madam Chair, distinguished panel members, ladies and gentlemen, it's a privilege again to address you this morning, but on a topic that is very worrisome for us in the legal profession, as well as for all advocates who really stand for the rule of law. Now, it has acquired a rather interesting acronym, SLAPS, that really, as Madam Chair mentioned, it means strategic lawsuits or litigation against public participation. One may think that this is a recent invention, something that perhaps has come about because of the challenges that offenders of the rule of law face. But really, if you think about it, for lawyers here, particularly and judges, this can really simply be described as abuse of process. It is nothing but abuse of process. So let's get that clear, all right? You can have any acronym you want, you can put it at a different level, and then with that, wrestle to find different principles to deal with it. But at the core of it, this is simply abuse of process. When the court process is used to target, intimidate, harass, oppress, whether a litigant or a lawyer, it's abuse of process. So let's call it for what it is, and then we move from there. I have some slides here, but I'm actually trying to speak off the slides because I think it is not something that we are unclear about. It's not something that we do not know. It's something that we're all familiar with. It's just a creature that's taken a different form, and it's become rather insidious as it is now. Because it targets. The court process is used to target persons who have the courage, the persons who stand for rule of law principles. Here we speak about environmental rule of law, but really it is no different from any other area of rule of law. If somebody speaks about it, then you have a person on the other side who is an offender who wishes that person to be shut up effectively. What is used is laws of defamation. In the UK, we have seen it even being used under the rubric of breach of privacy laws. Now, you know these laws have competing tensions. When one speaks about defamation, on the side of the persons who are either the investigative journalist who has discovered an environmental wrong or any breach of the rule of law, if you like, it may well be a publisher who chooses to publish that report, an editor who edits that report, or a person who then just disseminates the report. It could be any one of these persons, all of whom feel that this is a very strong piece of information that has acquired public importance. They are then slapped with a defamation suit by persons with deep pockets, and with sums which can only be described as in terrorem, because it'll have so much of a rippling effect everywhere that you are facing that sort of a suit. And then comes the tension. On the one side, the defenders would say it's a matter of freedom of expression. I have a right to speak up, and that right is a right that is, in many ways, as a constitutional right, the highest of the different freedoms. On the other side, you have the person who is the suing party saying that, look, I'm entitled to access to justice. And access to justice means I'm entitled to vindicate my reputation. How do you deal with those competing principles? And that's really the core of it. But I go back to how I started to say that let's recognize this creature for what it is. It is an abusive process. That's overriding, that's umbrella. After that, you look at where it comes from. Whether it's defamation, breach of privacy, or any other form of cause of action, which is meant to intimidate, harass, and really to silence. Because that's the effect of it. And if you think about it, that effect is not confined to the litigants. In as much as you think that it's only not my problem, the chilling effect of something like that, it is the effect that it silences more than litigant, it silences public opinion. It silences all those who may well want to speak up about this matter and will now be cowed into silence. That's the effect of slaps. That's the nefarious effect of slaps that we all must be clear about. How do you deal with it? Now, in the US, they have, of course, immediate recourse to the First Amendment, and the First Amendment itself gives rise to anti-slap legislation. So there is a sense of protection there. But we are in the common law world, and we deal with it differently. Anti-slap legislations are difficult to put on the statute books, simply because how do you describe what is a public purpose, for example, for which you have spoken? So you have that difficulty. But in a book that was written by Jeffrey Robertson, KC, called Lawfare, and really this is what it is. It's where it is termed, what is warfare, is today where the law is used for that purpose. And in that book, he spoke about how one could look at reforming certain laws when it comes to this category of actions, where it is clear that the target is really a person or persons who have spoken up in defense of the environment, who have chosen to expose a wrongdoing that concerns the environment, or as I say, any area of the rule of law. He says if you're looking at defamation, maybe we should change the laws. And those of us who are familiar with defamation laws, you know that the burden actually shifts the defendant to prove the truth of your statement. It is for me to say the statement was made, and it's for then the defendant to raise either justification, fair comment, and so on. Maybe it's time to change that the litigant, the proponent of the suit, must prove the truthfulness of that which is being alleged against him. And if you look at, and you know in defamation suits, the first thing that a litigant would do to silence you is to run to court to get some form of injunctory relief, some form of restraint, an injunction. Perhaps when that happens, you do not use your usual principles for an injunction, but because there is a public element, a public interest element in this, there should be provision in the law that the applicant must establish that there is no public interest involved in this. It's purely a private matter. So that may be, in a sense, a curtail or a restraint on persons who would otherwise willy-nilly go to court for an injunction. And when one speaks about breach of privacy, and if that is the cause of action, and that is the mode on which the silence is sought, then the litigant must again show that the privacy he or she claims has no public interest element in it. Because if there is a public interest element in it, then the court should be wary. The court should be alert that the process is being abused for a purpose which is ulterior to the case itself. Those are some of the reforms. He also spoke about the fact that perhaps in these cases, there must be a summary procedure. That means at the very outset, the court takes a view as to whether or not this is a bona fide claim for reputation or privacy, or whether this is really a masquerade or mask for a claim that is meant to persecute persons who have spoken up for environmental rule of law, if you like. Whether or not, I spoke about the burden of proof, whether or not the burden of proof should be looked at, whether or not the cost that is claimed in this court should be exposed so people know what really is behind this suit. It is meant to terrorize. Whether or not these cases are cases where the court will say it will be open to the public. So there will be televised hearings and everything will be open and people will know where this is coming from. There will be full exposure about this. And whether or not cases like this, Jeffrey Robertson has argued that perhaps it should go to the jury, should reinstate jury trials, where members of the public, and I mean no disrespect to judges here, but members of the public, not constrained by the strictures of the law, will see this for what it is and come to the correct decision. Unfortunately, much of these reforms have really not taken shape. And what that simply means is whether lawyers or the other defenders are still exposed to this abusive process. And I think the time is near for us to come to some sort of a resolution, certainly as international law bodies, to recognize this creature for what it is, to expose it, to come up with clear principles that will help guide us dealing with this. Not what's the flip of it. The flip of it is silence. The flip of it is wrongdoings would carry on under the radar and there will be really no restraint. We'll all still go back to saying on the one hand there is freedom of expression. On the other hand, there's access to justice and the right to vindicate my reputation. And that argument, that tension really takes us nowhere in the face of this abuser process. Thank you very much.
Thank you, Stephen. I think this is really interesting for us because for those of us in Papua New Guinea, we know that not only do we still have and recently have criminal defamation in our legislation, and it carries with it very severe criminal penalties. Let me now welcome Mr. Robert White, Barrister and Vice President of the Environmental Planning Law Association of New South Wales. So Stephen spoke to us generally about protecting defenders from abuses of process. Robert is going to address the particular challenges facing lawyers in upholding the environmental rule of law. Thank you.
I'm going to focus on 3 cases from around the world which illustrate some of the points that Stephen's just been making. Possibly the most egregious example of slap suits is the first of my examples, a case which may be known to many of you, Chevron against Donziger. In 1993, a class action was filed on behalf of 30,000 farmers from the Amazon region to seek compensation for pollution caused by drilling for oil in the Largo Agro oil field. Stephen Donziger was the lawyer acting on behalf of the plaintiffs. The Ecuadorian court awarded the plaintiffs $18 billion in damages, reduced to $9.5 billion on appeal to the Ecuadorian National Court of Justice. Chevron did not think much of that, and in 2012 filed a RICO case in New York against Stephen Donziger personally. RICO, you may have come across, Racketeer Influenced and Corrupt Organizations Act. We often hear about that in the news when cases are brought against Mexican cartel leaders or mafia leaders in the United States. The claim included against Mr. Donziger what became entirely spurious allegations that Mr. Donziger had bribed the Ecuadorian judges. The matter came before a judge of the Southern District of US, Judge Kaplan, who did not recuse himself from the proceedings, notwithstanding that he had substantial share investments in Chevron. He found that the Ecuadorian judgment had been procured by fraud, bribery, and racketeering activities. Chevron then decided to bring another case against Stephen Donziger, requesting access to Mr. Donziger's work files. Meanwhile, Mr. Donziger had appealed against Justice Kaplan's judgment, but notwithstanding the pending appeal, Judge Kaplan ordered Donziger to turn over his phone and all of his work files to Chevron. Mr. Donziger, whether you agree rightly or wrongly, determined that because he had an appeal on foot, he didn't need to turn over his privileged records, and Judge Kaplan asked federal prosecutors to bring contempt charges against Mr. Donziger. The United States Federal Attorney General declined to bring those charges, and having refused that, Justice Kaplan appointed a private team of prosecutors within his own court to pursue Donziger for contempt. The court, no jury trial, sentenced Mr. Donziger to 6 months in prison and home detention, and put a charge on his apartment. And in 2020, Donziger, because of the contempt proceedings, was disbarred from practicing law in the District of New York. So that's the first example. The next example illustrates a number of the points that were made by Stephen. This is a South African case which went to the Constitutional Court of South Africa, and the plaintiffs in that case were seeking to stop Australian companies mining for mineral sands in South Africa. And they were represented by lawyers, and the lawyers took part in a University of Cape Town lecture in which they had criticised the mining company. And what happened, as you can see on the slide, is that the mining company sued not only the plaintiffs, but also 3 of their environmental lawyers for defamation, alleging that the statements that had been made during the university lecture were defamatory. The matter went, as I say, to the Constitutional Court, and it's an interesting judgment because it goes through the history and origins of SLAP suits around the world and what's actually meant by SLAP litigation, as indicated by Stephen. Now, picking up on one of Stephen's points is that a SLAP suit is essentially nothing more than an abuse of process matter. That was the issue raised by the lawyers in this case, who sought to strike out the claim, the defamation claim, on the basis that it was no more than an abuse of process claim. The Constitutional Court in that case had to decide whether there's no legislation in South Africa preventing SLAP, so they had to decide whether the common law could entertain this kind of strikeout on the basis of it being an abuse of process claim. And what the court said is this, that the common law in South Africa can entertain an abuse of process claim, and that could be dealt with at an early stage in the proceedings. And what the court said is that the defendant lawyers would have to prove at trial that the defamation suit brought by the plaintiffs, 1, is an abuse of process of the court, 2, is not brought to vindicate a right, 3, amounts to the use of court process to achieve an improper end and to use litigation to cause the defendants financial and/or other prejudice in order to silence them, and 4, violates the right to freedom of expression entrenched in a part of the South African Constitution. So that was the outcome of those proceedings. And now I want to come to my final example, a little closer to home, a case in the Tiwi Islands, which is about 300 k's just behind me, off the coast of Australia, just off Darwin. And what happened in that case was that a claim was brought by the traditional owners of the Tiwi Islands against a gas project by Santos in the Timor Sea. The precise project was seeking to convey gas via a pipeline from a field in the Timor Sea to a plant in Darwin, and the traditional owners sought an injunction to prevent Santos from commencing work on the pipeline. The case brought by Mr. Mankara on behalf of his traditional owners was unsuccessful, and a cost order was made against the applicants, the Tiwi Islanders. But perhaps conscious of the fact that they may not succeed in enforcing a cost order against the Tiwi Islanders, Santos had another idea, and this was to make a cost order against the Environmental Defender's Office, which was the legal team representing the Tiwi Islanders. Now, many of you around this room may know of the Environmental Defender's Office. It's perhaps the major environmental law firm in Australia doing public interest cases, and has done many cases in the South Pacific and in Papua New Guinea, representing landowners here. There were 3 planks to the costs argument, or 4 planks to the cost argument. Firstly, an allegation that the EDO had funded part of the applicant's proceedings. Secondly, an allegation that the role of the EDO in the conduct of the proceedings was unmeritorious, in particular an allegation that the EDO had distorted Indigenous instructions. Thirdly, that the EDO had a substantial interest in the outcome of the proceedings, being an activist organisation. That was the claim. And fourthly, that the EDO had engaged in crowdfunding activities to meet the expenses of the litigation. And what Santos was seeking in this particular hearing, which is Mankara versus Santos number 5, was the production of EDO documents, so internal EDO documents with its clients in a subpoena so that it could ventilate and pursue its costs arguments. Now, it's important to note that in the principal judgment, Her Honour did not need to determine a submission that had been made by Santos that the EDO lawyers were the principal proponents of the action, pursuing it on ideological grounds. So there was no finding made by the court in that case. Her Honour noted that the issues in the costs application were novel, and ultimately allowed the subpoenas to be issued for disclosure of documents relevant to those 4 particular issues. Now, one of the arguments that was raised by the EDO in opposition to the subpoenas was that its circumstances were analogous to a community legal centre raising money to support its services, including important pro bono services in the community. And Her Honour said that was a matter for the trial, including each of the 4 issues raised by Santos, and that it was an insufficient argument to reject the subpoenas. The EDO on the subpoena fight deposed also through its chief executive that it would be oppressive to comply with the subpoenas, which would require a review of 33,000 individual documents for relevance, privilege, and confidentiality. Now, the EDO, probably most of you are aware, does not have a massive legal team or huge numbers of people working within its office. And it argued that the process of reviewing those documents would have a significant impact on the day-to-day running of the organisation, including because of the diversion of lawyers from important other projects and its limited financial resources. And the judge rejected those arguments, holding that the balance of convenience at that stage warranted the order issuing the subpoenas. Now, as you can see on the slide, the matter did not actually go to trial, and the EDO settled the case for some $9 million in indemnity costs. Now, as you might imagine, that kind of cost order and the adverse publicity arising from the case nearly broke the Environmental Defender's Office. Thankfully, it didn't. It is still going strong and as strong as ever, but it is a salutary example of what can happen in litigation in circumstances where a highly resourced adversary decides that it's going to seek orders of whatever kind against the lawyers who have commenced and brought the proceedings. So these are the types of claims that have been brought against environmental lawyers, as we've heard from Stephen, and in South Africa, defamation cases, contempt of court, subpoenas, which you may think, well, they're relatively innocent, but as we've seen from the Mankara case, subpoenas can tie up small legal firms in paperwork and divert them from their very important other legal cases. Fraud, racketeering, probably not so relevant in the Commonwealth, but certainly in the United States. And fifthly, as we've seen, non-party cost orders. And then finally, if orders are made and lawyers decide for whatever reason that they're not going to comply with those orders, ultimately contempt proceedings and then professional disciplinary actions leading to striking off from the profession and your ability to mount these types of claims on behalf of traditional owners. So, what are the implications for the environmental rule of law? Well, I think as Stephen's explained, they are profound. and deep and deeply worrisome, because one of the fundamental planks of the environmental rule of law is access to legal representation and access to justice, and these slap suits against lawyers are fundamentally undermining, in my submission, the environmental rule of law. So thank you very much.
Thank you, Robert. That was all rather sobering. It's very apt, therefore, that in closing our panel this morning, we will hear from Professor Jennifer Mackay, AM. She is a Professor of Business Law at Adelaide University, and she is going to consider how we as judges and the courts can ensure justice for environmental human rights defenders when they are seeking to uphold environmental rule of law. Thank you, Jennifer. Please welcome her to the podium.
Okay, excellent. Thank you. So I'm going to talk about a little bit about Australia, but more about how we could work together and using mechanisms of treaties to create some type of movement towards protecting environmental human rights defenders, who I include lawyers, and of course the general communities. So these is an example of who are human rights defenders, and as Stephen and as White has pointed out, we've got Indigenous peoples are very much activists in Australia at the moment, and of course here, community activists, scientists, journalists, youth and students, farmers, and of course lawyers and legal advocates. And the roles of environmental human rights defenders are all of these. Uphold Human Rights is the one that's getting some traction now since the ICJ advisory opinion came out last year. But they have an important role to raise awareness and educate. And I was talking to someone on the bus on the way in this morning about that, how to raise awareness in the community, advocate, mobilise and empower communities, stand against injustice and ensure access to justice. Now, this is a very famous Australian case where Lionel Murphy said Mr. Neil was entitled to be an agitator, and he was complaining about a public free speech issue. Unfortunately, in Australia since 1982, Mr. Neil as an agitator would be affected by very nasty laws at state level in Australia, particularly in my state, South Australia. It's got the nastiest law, but New South Wales has amended several acts to stop people assembling on roads, and Tasmania just labelled theirs the Workplace Protection from Protesters Act, and it went, when the Human Rights Council saw it, they said this is not an appropriate piece of legislation, and eventually the High Court did put a blue line through various parts of it, using our very weak constitutional provision about freedom of political communication. So unfortunately, we've had a regression in Australia, but I'm not going to talk about Australia anymore. I'm going to talk about how we can work towards some type of international movement to protect the class of human rights environmental protectors, who I'm going to mainly talk about lawyers and also about community groups. But the two are, of course, entwined. So they perform a vital work, as you know, critical protecting ecosystems, and it's particularly acute for First Nations and women defenders, where cultural identity and livelihoods are intimately tied to the natural environment. And there is an international legal architecture referring to environmental human rights defenders. Of course, all of that is not binding. It depends on your jurisdiction to the level of which it is, but they do exist. So there's the UN Declaration on Human Rights Defenders in 1998, and then there's the ICCPR and the Economic, Social and Political Rights, which Australia's signed and most people have signed, and there's the Inter-American Court of Human Rights, by the way, is excellent on lots of things, African and European mechanisms to reinforce state duties to protect defenders. And this all comes back to the human rights-based approach to law, which if more countries implemented it, everybody would be better off. But of course, the issue is the laws are fragmented. And in Australia, I call this, we have a messy mosaic of laws about protecting the environment, but we also have a messy mosaic of laws about protecting defenders and free speech and generally, and human rights generally. So, human rights environmental defenders are going to be most effectively protected when legal frameworks, social norms, market incentives, and institutional architecture operates together. And that's what I'm going to propose. Now, the IUCN Declaration on the Environmental Rule of Law is, of course, relevant to all of these. Clear and enforceable laws is a problem in Australia, and because we don't have that many clear environmental protection laws, but other countries seem to have clearer laws, including PNG. Respect for human rights, including the respect to a healthy environment, effective compliance and enforcement, that is the big one, and that's come up all of yesterday and has come up today in the two speeches. Effective compliance and enforcement is important. Equal access to information, participation and justice, accountability and anti-corruption mechanisms are all required, and we have them in some countries, in some domains. Those are very strong, so the models can be easily transferred. The use of best available science would be great too. So, law, rights-based governance. It's not merely legislation, but it is now going to be the human rights obligations and the climate advisory opinions. The ITLOS advisory opinion in 2024 was set the scene, and then we had the ICJAO, and these were pointing towards treaty harmonisation. The arguments that many countries took to the ICJ were that all the treaties are all separate, but the ICJ said no, they're all together and they are related to human rights. So we have that as a statement. Access to justice mechanisms are a problem as well. So now I'm going to look, I'll go through the four modalities, then I'll look at the Esquazu agreement in detail, because I think that's the best. Combined with the Luxembourg agreement, you get a bit of a start towards a modality to make some type of treaty. So norms, legitimacy and cultural expectations. We all know that you can have all the laws that you like, but if the public doesn't accept them, they won't be accepted. We have a heightened public expectation of consultation now, which is showing in the cases that you mentioned and the SLAPS cases, I think in almost all jurisdictions. We have Indigenous participation norms being written down. Australia has just produced its community participation guidelines under the EPBC Act yesterday, but they're doing an Indigenous one separately. That hasn't come out yet. ESG as an expectation, well, not amongst a lot of the community, but amongst legislators and politicians. That's more in the currency of everyday speech. Corporate social licence is a big issue, which has been examined in many domains, and climate responsibility, thanks to the UN Framework Convention and the COPs and all of those events. I went to the COP in Belém last year, and it was marvellous to see the number of community groups that were present, including the people from Fiji and Vanuatu who took forward the ICJ case, the young people, they were there. So the market, ESG and sustainable finance. ESG reporting is now much more common. It even applies in Australia. Climate disclosure obligations for listed companies are much higher. Sustainable investment, green procurement, and carbon markets, as we heard about yesterday. Plus, director due diligence duties are certainly a part of our law, and they're part of many countries' laws. So these all blend to bring around a market-based approach to this. But the important thing is the institutional and governance architecture to implement strong laws. And it's not only EPAs, but it's public participation, and that should be a right. And platforms monitored and reported on, meaningful clearinghouse mechanisms, monitoring institutions so decision-making is transparent, and independent courts. The Esquazu clearinghouse mechanism and the Luxembourg model has a good example of both of those. Now, just to remind you, the Esquazu agreement is new, 2018. It's Caribbean and American regional instrument. It has, the core obligation is Article 9. The states must ensure defenders can act free from threat, restriction, and insecurity. And it protects life, personal freedom, freedom of opinion, expression, peaceful assembly, free movement, and the capacity to exercise access rights. And it has a prevention, investigation, and punishment duty. So, most treaties stop short of listing this, but this one has listed enforcement mechanisms. Okay. And then it goes on to have some supporting provisions. It can't, there's a non-regression clause. It has a clearinghouse mechanism for exchanging information and good practice on defender protection, a public document. And the institutional follow-through has been an action plan on human rights defenders in environmental matters at their COP, which was April 2024. So it creates a bit of a cultural shift. I think the Esquazu Agreement is a great example. The Aarhus Convention, which you probably all know about, is older. It just stops at saying that you shouldn't prosecute, penalise or harass an environmental human rights defender, which would include SLAPS cases. So, I was going to talk about our act, but I'm not going to talk about that. So, judges and the environmental rule of law. Courts play a significant role in safeguarding civic space through all of these provisions we have heard about, and there are ways at which environmental human rights defenders can seek protection, but only where you can massage the common law or an anti-SLAPS act if you happen to have one. The ACT has one, by the way, but it's incredibly poorly drafted, so nobody really uses it. So future reforms should include explicit recognition of human rights defenders, anti-SLAP legislations, whistleblower protections, participation rights, environmental ombudsmans, and improved access to justice. Now, the Luxembourg Convention, as my colleagues have mentioned, is not been signed yet. It's fairly recent, and it's a landmark as it has a number of important provisions. The one that you didn't mention was the group of experts on the protection of lawyers. That's part of the convention, and that's going to have a role to assess how effectively states are implementing the convention's obligations. It can review reports, evaluate legislation, identify shortcomings, and issue findings. And that's going to be convened as a group of experts from around the world to monitor this convention, or this potential convention. So if we look at the Esquazu, which I think is excellent, and the Luxembourg together, we have binding duties in both, and that's what you need. To investigate, prevent first, and punish attacks on defenders and harassment of lawyers. The norms are they're framing environmental human rights defenders as legitimate public interest actors. Here we're entrenching bar independence and self-governance. Thank you. The market shields lawyers from professional retaliation and income loss. And the architecture, the expert group. What does the expert group remind any of you of in the international treaty domain? What's the most successful international treaty on environmental matters? I asked my students this, they didn't know either. Montreal Protocol is the most successful, and that is administered by an expert group of scientists who go in and help countries achieve the reduction of the relevant chemical. So that is a very good and important point, and that is a very good part of the architecture which has previously been missing and is now being stated in both of these two conventions and potential conventions, yes. We have problems in Australia. So the crucial question is, if we protect environmental human rights, if we create greater and better roles of public participation in environmental decision making, then we won't need to protect environmental human rights defenders because they will be able to participate in the process. And that is what now Australia is working on, and many other countries are. But we still need to protect the environmental human rights defenders in the short term. The advisory opinion has mentioned this point, and it did mention that the importance of environmental human rights defenders, and as we heard yesterday, there were 96 parties and 13 NGOs were invited to make submissions, and many of those were really environmental human rights defenders. The advisory opinion also said that everything, the Framework Convention, Paris and human rights law is a coherent, applicable law that works together. It's not a divided, siloed set of laws. So that's very important, and we'll see how that's used in the future. So, sources of international legal obligations for climate change. They're going the treaties of the climate regime, human rights obligations, and duties under customary international law. So the ICJ said that these are the three aspects, and clearly protecting environmental human rights defenders can come under all three of those. So, summary. We have a wicked problem of environmental protection, as we all know, and we've overlaid it by a wicked problem of the law in many ways, within the sense of the way the law is siloed, and environmental laws are particularly siloed. So, environmental human rights defenders are now in the middle of a moving feast of changes to both law, cultural norms and values and ethics. The market incentives and the market regulation has been improved, and all of that results with a change in the architecture. So we are in a very interesting phase, and the way that the advisory opinions will be used persuasively in domestic courts will assist environmental human rights defenders. But the most important thing is to try and get some type of focus on environmental human rights defenders with the legal architecture to assist in the development of external reporting bodies and COP-type events in order to get the information out to the general public to improve the education. So this was what was said about the SDGs. We envisage a world of universal respect for human rights and dignity, the rule of law, justice, equality, non-discrimination, a just, equitable, tolerant, open and inclusive world in which the needs of the most vulnerable are met. And I think it would be wise to try and Continue to remember that and to focus on, when you get an opportunity to talk to people, about getting a transparent legal architecture about reporting abuses of environmental human rights defenders and about improving the treatment of them in domestic spaces. That's all.
Thank you, Professor, and please a big round of applause to all our speakers this morning on this very important topic. Now, I'm very grateful to my very experienced speakers because they have all stayed within time and they have allowed us an opportunity for questions. I will not be a greedy moderator, but I do have a question of my own. My question is, and I really want to understand, I'm going to start with Stephen, and then I'm going to ask if any of the other panellists agree or want to add or disagree. What particularly should judges do or not do when confronted with a case that they suspect might indeed be one of these litigations? Stephen, starting with you.
Thank you very much. I'll put it differently. I have a wish list. And uppermost in that wish list, and this wish list is not in the present position as a president of an international law organization, but as an advocate for persons who are marginalized and oppressed. And my wish list is this: the judges are conscientized. You're conscientized to this problem that we have. Because you know, when we talk about judges being, and I speak with the greatest respect for all judges here, I've been an advocate for 35 years, appearing before different judges at different levels of courts in my country. I ask for conscientization, that look to your conscience, understand where this comes from. We don't stand up for goods sold and delivered. We stand up for human beings. We stand up for lives. We stand up for livelihoods. And when we are targeted, when our clients are targeted, we ask that you look at your conscience, realizing that in the common law world, when we say that the judges are the last bastion of protection, that means something. It's not a perfect solution. We are all imperfect, but that means something to us, those advocates who stand as defenders, for those who we speak for. Recognize where we come from. Look to your conscience. Keep to your oath of office. Do what is right.
Did anybody want to add or? Can't add to that. Yes, Matthew, please. Could we pass the microphone to Matthew?
So I acknowledge the Honourable President of the Commonwealth Law Association, and I should also point out they have written a very, very great document on the Luxembourg Convention and urging people to sign it. Also, Stephen and I realised that we were called to the bar, different bars in 1991 at the same year, and I had the privilege of practising in the Land and Environment Court and running cases, and I never suffered, any of these threats of harassment. And I think that's something that we as Australian lawyers often have to recognise, that we have been in a very, very privileged position because of the role that the judges do play and the strength of the independent judiciary. But if I could also add or two practical comments. One is that the Aarhus Convention that was mentioned, which is a European convention but is now open to signature for all countries around the world, has the only special rapporteur on environmental and human rights defenders provisions that exists in the world. They do have a rapid response mechanism. Michel Forst is the first special rapporteur, and it reports regularly to the Aarhus Compliance Committee and has made strong condemnation to the United Kingdom in their treatment and their prosecutions by the state of climate defenders and climate change activists in particular. So there is this mechanism that we can look at through the Aarhus Convention, which is now open for signature for any country in the world. And the second thing is, if we want to look closer to home, the Indonesian Supreme Court have done a significant amount of work over the last few years in developing a direction and a process that the court and the judges follow and we have Judge Bambang and other Indonesian representatives who have done enormous work to ensure that the courts and the judges in their practice of environmental law have a great conscience that they can examine, but they also have a good court rules that can say, in these circumstances, this case is likely to be a slap case, trying to intimidate or threaten people in the exercise of their lawful rights. I also say that the Indonesian environmental management law, environmental protection law, has an amazing provision that says that any person acting to protect and defend the environment shall not suffer civil or criminal proceedings. Not always followed, but it is that idea, and I think as Jennifer said, we have to work on all these levels. But those are two important things. There is an international mechanism that we can use, and there are courts that have adopted very, very good, strong procedures to protect those who are seeking to enforce their rights before the court.
Okay, thank you. Now, I'm going to throw to the floor. I won't be greedy. But I do ask this, please state your name, stand up, state your name, state your title, ask your question, no speeches, and direct it to someone on the panel, okay? I can see Justice Gator has a question. You may remain seated, Justice Gator, but if we could have the microphone down to Justice Gator, please. Thank you.
Thank you, Judge Berrigan. Hello, thank you, Judge Berrigan. I'm Judge Gator from Papua New Guinea. Please excuse me. Allow me to sit down so I can think a little clearly at this point in time. But, ladies and gentlemen, and the esteemed presenters, I've been at awe with the amount of valuable information since yesterday and this morning. I went home dejected that with all that wealth of information and now putting on my mediator cap, having had both sides of the arguments, and I am now asked with this question, and if I may use Justice Preston's series of lectures he delivered to the judges this week. The forms to fit the fuss. How do we find the forms to fit the fuss? And more recently, just having heard from Professor Jennifer McKay, the wicked problem. How do we fix the wicked problem? With all those, number one, the ICJ pronouncements, the Luxembourg conventions, and all those conventions that you have explained to us, including the experiences from India yesterday and the good practices, and those in PNG where we are struggling. We've made orders and the developers have decamped. Where do we go from here? And as a small nation in the Pacific Islands region, our task is immense. How do we see that the orders that we make are enforced, if not internationally, but collectively? So I see Judge Berrigan is standing up. Let me cut short here. The international norms and the architecture, I like that word. Can we, as a colloquium here, and again using Stephen Theo's, he mentioned about a resolution. What can we do, or what can the International Forum do to help small Pacific Island nations so that we walk away with something meaningful? Thank you.
An excellent question, of course, Justice Gator. Who would like to begin with that?
the reporting mechanism that you mentioned, and also the UN has an environmental human rights defender. It was Mary, someone from Ireland, and now it's somebody else. So they do report. So, I mean, I don't want to tell a judge what to do, but certainly the bodies in government should encourage, if there is a problem, reporting of that. But I think your point, when you as a judge get a case that does look like a slaps, finding all the smart things in your law to call that out. And that might be to create a precedent that this is an abusive process, which it might be a stretch of I don't know your laws, and then you've got a hard line in the sand, and that will do the reverse, which we all want, to chill the belligerent. There's some very clever lawyers in Australia who took on AGL. Do you remember AGL is our private energy company, and they promote themselves as being sustainable and paint silos with saying how great they are. A group got advice, and they changed the words to say Australia's greatest polluter and so on, and they got away with it because the copyright law has a provision for social comment and satire, and they used it. Now, those people didn't come up with that themselves. They got advice from some clever lawyer under the lap. So you can't do that as a judge, but I think when you see a matter, really find that it is an abusive process would be the way to go.
I was just going to add that with these problems, there's no quick fix, okay? But lawyers are smart people, and over time, we can use existing instruments, or we can devise new instruments like the one that I've spoken to and Professor McKay has referenced as well. And over time, we can think of clever ways in which we can build up jurisprudence that actually does tackle this problem. Any period in history where there was challenges, to civil rights or anything that you might want to counter over a period of time, there was an inflection point where it seemed like things were getting worse and they were never going to improve. Until smart people like lawyers came together and said, we're going to find solutions, we're going to put our heads together, we're going to use our grey matter to come up with solutions, and that's what we need to do with this problem as well.
Okay, thank you. Judges are clever too. And we are clever here in Papua New Guinea. Our abuse of process, the precedent on that, we have very broad powers, inherent powers, with respect to abuse of process in this jurisdiction. So that's important to bear in mind. Can we have one more question? I think we have time for at least one more question. All right, 2 more questions. We're going to go Justice Collier and then Justice Leosi. Thank you.
Thank you. Can you hear me? Yes. My name is Bernard Collier. I'm a judge of the Supreme and National Courts of Papua New Guinea and also a judge of the Federal Court of Australia. And I just want to thank the presenters for their very interesting presentations this morning. I have a response, but I'm going to frame it as a question. And my question starts off by saying judges do have consciences. We are here to administer justice. Most judges will do that, and like I'm sure everybody else in the room was horrified by the story of the Chevron case. But in a world of AI, where judges are constantly being given material which is being confected, why should environmental lawyers be protected if they do that exact thing? And in the Mangara case, that is pretty much what happened. I know quite well the judge in the Mangara case. If you look at that case, she ordered costs against the Environmental Defender's Office because the experts they had engaged, basically, in her honour's view, confected their evidence. And in Her Honour's view, they had wasted the time of the court and the costs of the other parties. So why shouldn't those lawyers be basically punished for wasting the time of the court? Because I can tell you as a judge, hell hath no fury like a judge who is misled by lawyers. When we trust you, we trust lawyers to give us accurate information.
I'm sorry, Your Honour. That is not what was found in the case. The judge in the primary matter did not make any adverse allegations against those solicitors, and those solicitors were not ever sent to any professional. There is no adverse finding against those solicitors. What you have said just then is the precise form of defamation approach that corporate entities are taking against environmental public interest lawyers. I find that statement that you have made inappropriate in these circumstances, Your Honour, with great respect.
Quote, my concerns about Dr. O'Leary's independent credibility are such that I would not accept his evidence as sufficient to establish any scientific proposition at all, even if his evidence had gone unchallenged. My conclusions about Dr. O'Leary's lack of regard for the truth, lack of independence, and lack of scientific rigour are sufficient to discount or dismiss all of his reports for all purposes. I have concluded that the cultural mapping exercise and the related opinions expressed about it are so lacking in integrity that no weight can be placed on them. And this was the expert, my understanding, and correct me if I'm wrong, who is engaged by the lawyers in this case. So my understanding is that's what happened. I'm not saying that lawyers should be chased, persecuted, but I do say, as I said, hell hath no fury like a judge who's misled.
Your Honour, you just cited the judgment in respect of the expert witness that the judge, in the exercise of their discretion, discounted. You then have elided that the suggestion that that finding is applicable to the solicitors, where no disciplinary proceedings against those solicitors were ever undertaken, nothing was ever referred to the Law Society, and it was only that observation. And I have to say that that is where, with respect, one can make the findings about expert evidence. That's within the matter of the judge. No credibility is attached. But to then draw that conclusion in an open forum that affects the personal reputation of those lawyers and the law firm is exactly like the Dotzinger case. These are things that should not be done, Your Honour.
Then let me simply respond by saying I'm sure Justice Charlesworth took all of this into account in making the orders Her Honour did. Her Honour would not have made the orders Her Honour made without thinking about it very carefully and taking into account all the material that was before the court. Thank you.
All right, thank you. We're going to leave that there. I think to two people I know quite well, I think we might continue this conversation outside, who I know quite well and really like. Can I ask, Justice LAWASIA, can you close us off with a really short question before the break? Simple answer would be helpful as well. Microphone, please. Thank you, Judge. Go ahead.
Thank you. Justice LAWASIA from Papua New Guinea. I don't know whether this is going to be a question or a comment. Okay. But I think it's directed to Stephen Thiru and the other speaker. Sorry, I forgot your name. But anyway, I thought courts were supposed to be the last bastion of hope. That's what we all know. And that's supposed to be the case. But I am just pretty much discouraged with one of the cases cited from the district court in the United States. I think it's Justice Kaplan. Exactly, that's what I'm asking. What's supposed to happen in a situation like this where, well, from what I've heard, there's something wrong with the decision Justice Kaplan made. I mean, we are supposed to be defending the climate change, protecting the climate change in our decision-making process. But now I hear, and thank you to speakers up there, I'm hearing something else. That's not actually the case.
Is there a question?
We're not
Councillor?
helping. No, I'm just making a comment here.
Okay. Well, I think,
And perhaps I would like some comments on
all right.
particularly Justice Kaplan's decision about what he did in that, I forgot the name of the case,
Okay.
Donziger case, yes.
All right, thank you, Judge. I suppose the first thing that we can do is we can be aware. Awareness is incredibly, forewarned is forearmed. I will ask somebody to give a response, if they would like to, on that. I mean, I'm interested to know what happened to poor Mr. Doniger. We left him struck off. Where is he?
I think there is a bit of an update to that. Can you hear me? Yeah. When President Biden left office, 2020? Yeah. No, it wasn't that long ago, was it? He in fact was asked by a number of senators to pardon Mr. Donziger, but he didn't. So that's the last I've heard, is that he's still acting for people, but not in a professional legal capacity, but is still helping people. I should add as a bit of a postscript that the people in Ecuador have not seen 1 cent from the award. And the great irony about this is that actually the case was filed by Donziger in the US, and Chevron sought to move it to Ecuador against Mr. Donziger's wishes, but it was ultimately moved to the Ecuadorian court. So I don't know why that happened. But.
All right, thank you. I'm afraid I know we could go on with questions on this topic. I encourage you to corner our panellists over morning tea. Can we, before we do that, can we give them one final big round of applause? And we have a gift. Thank you very much. Somebody remind me what time we're coming back? 11 o'clock. Thank you very much, ladies and gentlemen.
Can we get a photo of the panel?
Yes, can we get, sorry, can we have a photo of the panel? We want to get a photo of the panel.
Chris will say, I need this.
Is this how we wear these?
Yes.
Thank you very much. Chris will say, I actually need this because of the way. Thank you very much for the moderation, and I apologise for losing my.
That's all right.
Yes, Jackie, are you there? My lords. Oh, you can. Alison is late. Few seconds. Ebony, where is the judge?
The more time we have for conversation and questions, the better.
Yeah. I don't want to be in contempt.
We're still waiting on Solomon.
Anyone missing? There is a student? Is that Leo?
Yeah, Solomon. Yeah.
Someone is not here.
He may be, but I really saw him.
My lords and ladies, I propose that we start the business of this session. Yeah, here. Sorry. Good morning and welcome, my lords, my ladies. I stand on the right on the protocol already established. I recognize our Chief Justice, the Deputy Chief Justice, and other Chief Justices here present, distinguished jurists and members of the legal fraternity, students, and lawyers who are here. Yesterday, I actually saw quite a contingent of them from Judicial Review and Appeals track. I was particularly overjoyed. I think I saw Rekaken here, I saw Kopi here, I saw Narakobi here, not the judge, but the daughter. There is a relationship between judicial review or administrative law and environmental law. I happen to be the track leader. My name is Justice Wahile Betuel Kidingaki. I'm a judge here. There is a relationship between administrative law and environmental law. Environmental protection is largely implemented through administrative agencies and procedures. That is where the relationship is. And by that, I am also trying subtly to lobby the Chief Justice and the Deputy Chief Justice to allow LAWASIA Conference on Administrative Law to take place in the course of time.
Without wasting much time, I'm not going to read the bios. They are all there for you to read in the book. All that I'm going to request of my distinguished panelists is that self-regulation is better. They have 15 minutes, and that should be enough. They shouldn't go beyond 15 minutes, so I prefer self-regulation than approaching you. So if that is permitted, we are going to start. I think it's a joint presentation between Professor Amanda Kennedy, who is the Dean and Head of School of Law, Queensland University of Technology in Brisbane, Queensland, and the Honorable Justice Preston, Chief Judge of the Land and Environment Court, New South Wales in Sydney. And I'll start with them. I don't know who comes first. Please, the floor is yours, and you have 15 minutes.
Thank you, Chair. So this session here this morning, and certainly the paper that Justice Preston and I will be presenting to you, covers slightly different ground to many of the other sessions that we've heard so far. We're not talking about substantive law, we're not talking about the architecture of courts, but judicial education and the capabilities that it seeks to build and its important role in upholding the rule of law. We're going to draw on our participation in judicial education programs across Asia, and particularly our recent work in Cambodia, in Lao PDR, and most recently in Papua New Guinea. I should note at the outset that the programs that we are talking about today, particularly those in Cambodia and Lao PDR, were variously organised and led by our colleagues Bryony Eales, Martin Cozier and Dr. Matthew Baird, who are all here in the audience today, working under various institutional auspices over several years, and we thank them very much for their leadership of these programs. Our own involvement, both mine and Justice Preston, was quite specific. Justice Preston was engaged as a judicial expert in environmental law, and myself as an expert in legal pedagogy and environmental law education. So our reflections today are very much given from those vantage points, rather than an account of the programs as a whole. So I will speak to the program design and pedagogy aspects, and His Honour to the judicial craft and how he has incorporated that into capacity building. I want to start by briefly stating the premise that underpins our approach. Environmental disputes are difficult to adjudicate for various reasons, and we see some intersections here with environmental law as a whole and some of the challenges that we have as environmental law educators teaching this area of law. Environmental disputes are scientifically complex, so the court cannot evaluate the central evidence from its own knowledge completely. They are polycentric, with many affected interests, and they are rarely a neat bilateral contest. They are also, of course, value-laden. The trade-offs are contested, and the law often does not resolve them neatly. And finally, they are often forward-looking, with potential harms not yet known and lying well into the future, or in some cases, not too distant future. Now, of course, none of these features are unique to environmental law, but what is distinctive in environmental disputes is that frequently they all arrive together. And typically, not one of these challenges is resolved by knowing simply more environmental law. What they demand is judicial technique. And on that note, I'll hand over to Justice Preston.
So Amanda said what we're doing when we're judging environmental problems, we're trying to be responsive to those environmental problems. And the tool of judging is the same, but it needs to be adapted in order to be responsive to the environmental problems. Now, there are two sets of tools that judges use to adjudicate or judge a particular dispute. The first can be described as the substantive law. That's what we think about, and when we come to legal education, that's what most the greatest focus is upon the substantive law. So we think about the civil, the criminal, the public law, and we can break that sort of public law up into particular statutory, planning and environmental and resource law. We can think about the law of real property. We can think about customary law. All of those are substantive law. And as we're going to show, what we're doing when we're teaching judges, there's a little focus on that, but not as much, because we're going to come to what we do with these tools. Now, the other set of tools has been described as adjective law, because it is law that modifies and enables those tools of substantive law. So it includes the practice and procedure. How do we case manage? How do we conduct a hearing? The evidence, the rules of evidence which govern the admission of evidence into the hearing. And the remedies and sanctions. If we find a breach of the law, what remedies and sanctions will we impose? So that's another set of tools. So we've got two sets of tools, the substantive law and the adjective law. Now, how do we use those? That's the real craft of judging. It's no good having all these tools and not knowing how to use them. And so the focus is on and this is Carl Llewellyn's quote, the ways of handling these legal tools, the substantive and adjective law, to the law job ends. And one of those law job ends, of course, is adjudication, the judging. Now, we're coming to, let's unpack a little bit more about what that craft of judging is. So we can see it coming up to the hearing, so the case management that we engage in leading up to the hearing, the craft of conducting the hearing, and that includes receiving evidence, and then we come into evaluating that evidence. And that part of the evaluation is part of adjudication, and I'll unpack that a little bit more in a moment. And in the adjudication, we're going to use legal reasoning and legal method. And so we need to teach that. And of course then there's the craft of writing the judgment, the reasons, the explicit rationality that is the hallmark of adjudication. We need to give the reasons. And overarching all of that is ethics. And we need to understand what are those ethics that should bind the whole process of adjudication by the judges. Just come to that adjudication, because I want to just unpack what is involved, the legal reasoning involved there. And we could describe it as a syllogism, a type of syllogistic reasoning. Now, if you remember what a syllogism is, it has a major premise and a minor premise, and then a conclusion that's drawn from those premises. Now, what we're doing when we're using syllogistic reasoning in adjudicating an environmental dispute, the major premise is the substantive and adjective law. We're going to be finding the law that we're going to be applied. If it's a contract case, it's a tort case, it's a statutory environmental planning case, if it's a criminal case, we have to find what that law is, because that governs how we resolve this dispute. But we have to make that law come alive in the facts of the case. And so therefore the minor premise is finding the facts. And those facts that we find are going to be the facts that are relevant to the substantive and adjective law that we have selected as being appropriate to decide the case. Then we apply the law to the facts and come up with a conclusion as to whether there is some breach of the law or some legal consequence. And then that often requires us to make some remedial order. It could be in civil matters, a civil remedy, and in criminal matters, it'll be a criminal sanction. And so that's the overarching craft that we're trying to do.
So on average across the programs that we have been involved in, a considerable portion of the program is dedicated towards the judicial craft that Justice Preston has spoken about. Access to justice, practice and procedure, evidence, remedies and sanctions, dispute resolution, adjudication and giving judgment. A little more time is spent on problem-based application, and then there is usually some time for some comparative materials, and then, where necessary, the corpus of environmental law. However, this is always calibrated to the jurisdiction. It is not a single model that is applied everywhere. So in Cambodia, the work that we were involved in there was with the Royal Academy for Justice alongside the Asian Development Bank's Law and Policy Reform Program, and a series of workshops throughout 2023 and 24. This was a judicial academy with a standing training mandate, so the materials could become a curriculum rather than just a one-off workshop handout. In Lao PDR, the entry point differed. The People's Supreme Court had adopted the International Framework for Court Excellence, and environmental justice had emerged from the court's own improvement planning, and that had been preceded by a needs assessment conducted by the court itself. So in this case, there was significantly more substantive law taught because the judges were being introduced to an entirely new legal regime. And again, I need to commend the work of Martin Cozier here in essentially assembling an entire environmental law curriculum that formed the basis of that judicial training program. The third program, of course, that we've been involved with this week, and many in the room were also involved there, working with the PNG Centre for Judicial Excellence. And here I must commend the excellent work by Justice Carey and the team in assembling a workshop that, again, dealt with an established legal regime and a common law tradition, so the focus was very much craft-led from the start, but with local specifics at the centre of the problems rather than being considered on the margins. So this is not an exception to the model that we have put together, but calibration in practice. The craft orientation presupposes a substantive regime to work with, but where the regime is new or underdeveloped, then the corpus of environmental law needs to come first. So to the method, which matters as much as the content, the program uses 4 modes. We have presentations from trainers, facilitated small group discussions on set questions, and practical exercises using hypothetical problems. Finally, there is some time dedicated to preparing and giving reasons for judgment in hypothetical cases. A few things to note about that sequence. Judges learn by deciding. A lecture positions a judge as a student, a role that many have not occupied for some time, whereas a problem positions a judge as a judge. The problems that we use are hypothetical. We don't tend to put judges in positions where they may be hearing or rehearing the facts of a case that may be live or recently decided, to avoid putting anyone in a position where they need to be considering decisions of their peers. So we craft hypothetical problems that give rise to real legal issues in the jurisdiction. Justice Preston is going to speak a little more about some of the governing principles that underpin our approach.
We've talked about in other sessions about the integral importance of the independence of the judiciary. And if there's going to be training of judges, it's important that we maintain that independence of the judiciary. That means that insofar as there is training for judges, it should be judge-led and it should be delivered by members of the judiciary. And this, the IOJT Declaration of Judicial Training Principles adopts a number of those. So we can see Principle 2, that the judiciary should be responsible for design, content and delivery to preserve that independence. Principle 9, the commentary to that, judges who deliver the training should themselves be trained in the principles of adult learning. And that's important because when we're trying to learn, it's no longer, as we said, where we're the students back at law school. We're now actively involved as judges, and so we need to understand as adults how we can most effectively deliver that training. And Principle 9, the external experts should be involved, such as Professor Kennedy, but it's done under the authority and management of the judiciary. So here we've had, the PNG Centre for Judicial Excellence, is the overarching body responsible for the training. And Principle 10, there needs to be assessment, and so that we get this monitoring of the performance and a feedback loop so as to improve the ongoing delivery.
And so that brings me to the component that I have been responsible for in various of these programs. Principle 9 requires that training be judge-led, but its commentary requires something more than that. It requires a judge who is involved in delivering training also be themselves trained in principles of adult learning. So in various of the programs that we have run, alongside the substantive program, I will also run a Train the Trainer component. And it is a course in legal pedagogy rather than in law or juristic method. It draws on the principles of adult learning, on how experienced professionals acquire new practice, which is generally not by simply being told. It addresses facilitation, how to construct hypothetical problems that have more than one defensible answer to allow for deep discussion, how to frame questions at open deliberation, how to manage small groups in which a senior participant may take a very firm early position and not wish to be swayed from that position, and how to resist the impulse, which is strong in anyone accustomed to deciding, to resolve a disagreement that an exercise may otherwise wish to sustain. Now, none of those skills necessarily follow from being an excellent judge. Adjudicating well and teaching well are different skill sets. And a judge trainer who is given subject content and nothing else may very often revert simply to lecturing, because lectures are what they are themselves familiar with from their own time as a student. So content-only Train the Trainer programs essentially reproduce the pedagogy that they are meant to displace. So by bringing this element of pedagogy training in and upskilling our judges with effective training skills, they are in a position where they can more effectively build capacity in their cohorts. Essentially, what we have tried to leave in each of these programs is not a set of judges who simply redeliver our materials, but a cohort who are able to adapt and refine the materials and write the next set of problems themselves.
Oops. There we go. Okay, so what we've been doing in 3 of the programs, what lessons can we learn for judicial training in the Pacific? Well, one thing we've found is this craft-based model of training does transfer well. Case management, the evaluation of expert evidence, the crafting of enforceable remedies and orders are as relevant in Port Moresby as it would be in Phnom Penh. And so does the problem-based method that Amanda was talking about, the case for invented facts, is even stronger here because the judiciaries are smaller and more collegial, and that makes the delivery much easier. When you've got huge judiciaries, the judicial training does place difficulties in delivering this very boutique and custom-made approach. But also transferable is the fact of judge-led delivery and the train-the-trainer structure. And so, and having a regional network where the judiciary is smaller works well. Now, some things, however, need to be adapted to the particular society and culture or plural cultures in a country. So when we think about in Papua New Guinea, customary tenure and the sort of customary laws can reshape the approach to standing, the approach to crafting the appropriate remedies, and what it means to engage in consultation, that public participation, one of the access to justice principles. And the Constitution of Papua New Guinea speaks expressly in its national goals and directive principles to the environment and to future generations. And a lot of these interpretive resources don't exist elsewhere in the region. So you need to adapt the tools, that craft-based training approach to suit the particular conditions in a country. And of course, when we're dealing with environmental problems, one of the triple planetary crises is climate change and its consequences. So climate vulnerability in countries such as Papua New Guinea is not a scenario to be modelled. Rather, it is a lived reality that's arriving in the courtroom as evidence. So, if we just bring to conclusion, courts are not only adjudicators of environmental disputes. They are, of course, enduring institutions. So governments might change, programs and policies might change, funding cycles end, but the court is still here. It endures and is there to decide each subsequent case. And that's why capacity, once it's built, is not only worth building, but it also stays in the institution long after the program that created it. Which is why there is a good argument for treating judicial capacity building as an institutional pillar of the environmental rule of law, rather than just a series of events. And for building it with judge-led, with national institutions, and with proper respect for the independence that makes a court worth building capacity in. So thank you.
Thank you very much. Honorable presenters, I think we have been taken on a very interesting learning curve on the intersection of judicial pedagogy and judicial craft. The theory and practice of education, teaching strategies were illuminated, and very interesting points that emerged, including an emphasis on, especially in judicial craft, that not every fact is relevant and that not every fact matters. I guess only the dispositive fact is the one that matters. So that intersection, quite important. Thank you very much for that illuminating discussion. A round of applause again for them. We move straight to the next speaker. Honorable Justice Milion, Chief Judge of the Denpasar High Court, Bali, Indonesia.
In the first year of as career as a judge, I got opportunity to learn environmental law enforcement training. And the wise professor said that judge can take a role as a teacher for the nation, teacher for law student, teacher for the community. So right now, I am take a role more as a teacher, mentor, or facilitator rather than handling a case. So in this presentation, I will share about experience in Indonesia, how to make a training, and also it's not just training, but certification is a choice for judiciary in Indonesia to improving judges for handling the cases, especially in environmental cases. Oops, sorry. So the content of my presentation is about strengthening judicial capacity, a framework overview, and also certification process and challenge, and way forward in, I think it's about a few years later, we must preparing what is the best choice to improving the judges for the training or for the improving of their skill. As a basic of the knowledge about Indonesian court hierarchy, this is simple. There are 3 levels. The Supreme Court as the highest judiciary, and there are 4 kinds of judiciary: general court, religious court, military court, and administrative courts. In Indonesia, there are 949 courts around Indonesia and 1 Supreme Court. So in the Supreme Court, there are 50 justices. Actually, if they are full, it's 60. And in all provinces in Indonesia, there are 10,162 judges. So it's difficult also to make training around Indonesia. Usually, annual cases in Supreme Court about 37,973 cases in year, and last year in 2025. Therefore, each justices in the Supreme Court resolves an average of 760 cases. And a part of this, about 37,000 of cases, is 921 is environmental cases in 2025. Environmental cases are cases concerning pollution, environmental degradation, natural resources exploitation, biodiversity loss, climate change, and other activities that threatening the human rights to clean, healthy and sustainable development and the integrity of ecosystem. About the law reform by the courts, I think this in environmental judicial system, in handling environmental cases, judges contribute to law reform by developing new legal interpretation. For example, in Dutch language, rechtvindig, judicial activism. This means they do not rely solely on written statutes, but actively explore and apply evolving values of environmental protection, scientific understanding, and community norms. In French language, la beauté de la loi. Through progressive interpretation, judges help modernize environmental law and ensure it responds to real ecological challenge faced by society. For the environmental judges certification system in Indonesia, so the basic as a legal basics is according to the Chief Justice decree. So it's not basic to the law, but basic on the Chief Justice decree. And we have a strength of this environmental judges certification, standardization of judicial competencies, monitoring and evaluation system, consistent foundation for the application of environmental law principles. But we also have a weakness of this system. There are no specialized environmental courts, so we choose certification system. In the certification system, there are how to make authority for the certified judges and how to make the best selection among the judges and appointment placement by Supreme Court and also promotion if there are the judge can give the best decision for the environmental cases. Monitoring and evaluation, every year we make a monitoring and evaluation, and also reward system is also a part of promotion. So environmental judges certification training every year also evaluated by National Environmental Working Group. This working group is under the Supreme Court. There are justices, senior environmental judges, academics, lecturer in environmental law, and also civil society. This is an environmental NGO. So they also have a weakness that judgment are not always progressive. So it is a part of evaluation. And reliance on the quality of training rather than specialized institutional structures. And about training and capacity building, the criteria for the selection for the judges must have experience, 10 years experience as a judge at the first instance. And without bad track record, if they get undisciplined, we avoid the judge like this. And right now, since 2011, where Chief Justice degree, and 2012 is first training, first certificate judges. Until now, there are 1,903 alumni of the training, and they got as environmental judges. And they have a duty in general court, and administrative court, and military court. Actually, military court is not a part of the environmental judges, but according to the needs that in the military court, also criminal related to the environmental cases involve military person. Judicial Training Center regularly conducts advanced training. So the training is not only a basic training, we make advanced training. And the part of the advanced training, we are collaboration with NGO, international NGO, and also funding by, for example, for UNEP or from ADB. We make advanced training. And specific for the material of advanced training is detailed, and we also learn about cases related to the environment problem. For example, it's environmental evaluation, restoration and damage, compilation and examination environmental cases in administrative court, and also related with climate change. So if we make an evaluation during 2011 until now, certified justice for environmental judges, the key achievement of Indonesia environmental judge certification system has been institutional consolidation, enhanced judicial capacity, and measurable improvement in the quality of environmental judges. The availability of regulatory framework indicates that since Supreme Court's Chief Justice decree in 2011 and 2015, the Supreme Court in Indonesia has successfully established a formal framework, evaluation mechanism, and a national-wide network of certified environmental judges. So an enhancement of judicial capacity and standardization of competence, although quantitative data are not reflected in the shared result, but based on the substance and mandates of the relevant regulation, it can be concluded that the achievement of the system is about a standardized training curriculum. So because curriculum is always evaluation every year, so perhaps in this year we change the curriculum with climate change issues and also issues of water pollution, and also enhance technical competence for the in interpreting scientific data, assessing ecological damage, and understanding environmental legal instrument. The guideline of environmental cases adjudication in a systemic impact of on environment law enforcement, the systemic achievement of environmental judge certification from 2011 until this year may be inferred as follows. Increased ecological awareness within the judiciary, a more strategic role for the courts in preventing environmental harm, a greater public confidence in the adjudication of environmental cases. So this outcome represents logical effect of an environmental judge certification system that has been in operation for more 15 years. According to the regulation, Supreme Court Regulation number 1 in 2023, regarding guidelines of environmental cases adjudication, I take note that there are 6 main points. So one is about recognizing climate change, because this is when we make certificate judges, issues of climate change is not a main point for the material for the training. So right now, as we learn a case about climate change, and we will make a training about climate justice in next October. And second is emphasize the interpreting of interest in legal standing and detailing the scope of the object of environmental dispute in the state administrative court. So specific in the state administrative court. The point 3 is clarify the interpretation of strict liability. Last year we have a new criminal code, but I think the legislative is not understanding about strict liability, because they also put strict liability in the criminal procedures. And point 4 is emphasize the interpretation of corporate criminal liability and handling of animal evidence units, wildlife crime among ASEAN countries is also increasing number. And point 5 is provide a guideline for the assessing scientific evidence. It's important for judges and how to understanding about expert testimony. And point 6 is detailing the procedure for adjudicating strategic lawsuit anti-SLAPP. As presented before, also talk about anti-SLAPP. Now the challenge and ways forward, I think we must, based on the evaluation of the National Working Group on Environmental Law, environmental law judges certificate should not be one-time achievement. It must evolve into an ongoing learning system where judges regularly update their knowledge on new law, scientific methods, and emerging environmental issues. And centralized digital platform is needed to collect, track, and analyze all environmental cases nationwide. This helps ensure consistency, transparency, and evidence-based policy improvement. Court should adopt a standardized protocol for evaluating scientific data and build a reliable roster of qualified experts. And judicial decision in environmental cases should undergo periodic peer evaluation to maintain high-quality reasoning, strengthen jurisprudence, and promote uniform standards across the court. So, a challenge in this adjudication of environmental cases, strong environmental judgment is meaningful only when it's effectively implemented. So, therefore, needs to move from adjudication to effective enforcement, ensuring that court order result in real environmental restoration and protection. And also, therefore, the challenge is not only to apply existing environmental law, but also develop progressive, science-based, and ecosystem-oriented judicial reasoning to ensure effective environmental justice. And the last slide. So, the ways forward, I think, for strengthening Indonesia environmental judge certification system, it must be focused on sustainable capacity building, strengthening judges' access to knowledge and expert resource, and creating peer learning method network across the region. At the institutional level, we need a stronger human resource management monitoring and evaluation together with better operationalization of the environmental case handling system. And ultimately, the goal is to ensure the environmental judges are continuously competent, well supported, and able to deliver consistent, science-based, and effective environmental justice. Okay, thank you.
Thank you, my lord. I see the Solicitor General is here, regular in my court. I think I was quite fascinated by the certification system in Indonesia, but I was not sure whether I got you right that you have 10,000 judges? Yes, quite daunting task to train. Two things that I got from your excellent submission, that Indonesia is certifying judges to ensure that environmental law is not just taught, it's also trusted. I think that is what the certification really achieves. And I'm sure it does also anchor competence in judicial craft and the rulings that emanate from the courts under that system. I think it's an interesting system. Thank you again. A round of applause for the judge. The next speaker is the Honorable Justice John Kerry, the Justice of the National and the Supreme Courts of Papua New Guinea, and Chief of the Papua New Guinea Center for Judicial Excellence. I said Chief, not Chief Justice. Honorable Justice Kerry, the floor is yours. Self-regulation, 15 minutes. Thank you.
Thank you very much, Justice Tanyake. I'm not going to allow all of you to be like judges. We are very good at sitting and being asleep with our eyes wide open. I'm going to invite you to stand for 10 seconds to just change things a bit, because I saw some of you sleeping with your eyes wide open. You may be seated. But imagine for a minute a judge sitting in court faced with an environmental dispute. On one side stands a community that believes a river has been polluted and its livelihood, health, and future at risk. On the other side stands a major development, a project that promises jobs, economic opportunity, and significant benefits for the nation. Before the judge are competing scientific experts offering different conclusions. There are questions of statutory interpretation. There are issues of customary land ownership. There are allegations of environmental harm. There are competing claims of private rights, public interests, and the interest of future generations. Each party believes the law supports its position. The judge must reach a decision. Yet the question I ask is this: how prepared is that judge to resolve such a dispute? In PNG, we were privileged this week to have Professor Amanda Kennedy, Chief Judge Brian Preston, Senior Commissioner Susan Dixon, and a few of our judges, Justice Teresa Berrigan and Justice Derek Wood, Deputy Chief Justice Kanda Kazi, not in order of seniority, who helped us to develop the knowledge, some skills, but an awareness of environmental law, environmental rule of law. Because most of us, if not all of us, have never done an environmental law course in university. Now, I do not intend to keep you here or speak briefly for as long as I can. So I'm going to get to it: judicial capacity and why it matters. That's the case I'm making to you today. Judicial capacity matters because when things come before the courts and judges and lawyers treat it as if it's just a regular dispute, things can go wrong. And so this is why judicial education and training in PNG, specifically for environmental matters, is something that we are moving from just an activity-based model to a competency-based model. We're moving away from asking how many people attended. Look at the room, 400. And we are beginning to ask the question, what changed? What changes when you leave here today? Did learning improve judicial competence? Did it strengthen institutional capacity? Did it improve the quality of justice delivered by our courts? These questions have been framed in what I call the CARE, the CARE model. This is something that has been invented in PNG that's being taught in universities in the United States as of 2027. That deals with context, which deals with the needs assessment for the training, alignment of the training to the judicial competency, the responsive design of case studies, and for those who are not sure, University of Nevada is the only university in the United States that offers a master's and doctorate in judicial studies, and the work we're doing in PNG is now being used as a textbook in those courses. Evaluation, measuring impact and change. Why does capacity matter? Many of you presented earlier and lamented the challenges of judiciaries you've appeared before, or lamented the fact that there have been challenges with environmental litigation and getting the outcomes you'd like to see as lawyers. And so in order for judicial capacity to be improved, there has to be competency of judicial officers and competency in lawyers, because for most judges, we rely on submissions from the lawyers. And when you have incompetent submissions, what do you expect? An outcome that comes from heaven? It requires the cooperation of all of us, the lawyers and the judges, to ensure justice prevails. I'm going to make the paper that I'm presenting available, so I don't need to read it and bore you to death. The key issue that I want to leave with my presentation is the CARE plus E framework model, which deals with evaluating context, the evaluation loop for continuous training, and this is something that we are rolling out in PNG as of 2027. For the last 5 years, we've done 140 training activities a year for judges, magistrates, court staff in PNG. Our Chief Justice, who is the chairman of our board, the Papua New Guinea Center for Judicial Excellence, has committed lots of money. And he's supported judicial education primarily to support those of us who are judges, magistrates, and court officials to improve competency so that we can deliver justice for the people of Papua New Guinea whom we serve and are privileged to serve. I conclude because I anticipate that you will have a lot of questions for my colleague panelists in particular, that building a learning judiciary is not produced by occasional training. So anyone who thinks you can just pop up to one conference a year or one training activity a year and believe you become knowledgeable, you're fooling yourself. The strongest courts in the world are what I've seen happen in PNG. We have a learning court. We have judges in the front row here all trained as trainers. That speaks volumes to the commitment that the PNG judiciary has to improving competency so that we can improve access to justice for the people of Papua New Guinea. Learning is continuous. Professional development is a judicial responsibility. In conclusion, that's the best words you could hear today from me. Distinguished colleagues, the environmental challenges confronting Papua New Guinea and the Pacific will not diminish in the years ahead. The question is not whether our judges will face these issues. The question is whether we will prepare them to meet these challenges with confidence, competence, and wisdom. I've mentioned the CARE and the CARE E+ model. You can find it on the internet because it's going very far in academia in the next year, I guarantee it. For those of you who are academics, you will see it in peer-reviewed publications very shortly. The environmental rule of law requires strong courts. Strong courts require capable judges, and capable judges are built through deliberate, structured, and sustained learning. If we succeed in that endeavor, we will not only strengthen our courts, we will also strengthen the rule of law, protect our environmental heritage, and leave a legacy of justice for future generations to come. Thank you very much for my brief intervention.
Yes, the intervention was truly brief. Chief of PNG Judicial Center of Excellence, you stamped the authority as chief in that field. He said that he has to be brief because he's anticipating many questions for his fellow panelists. So I think you know now where to direct the questions. But my revered brother, you made very profound assertions and profound questions you posed that I think we should reflect on. The assertion you made, I think, which echoed in the hall here, is that judicial capacity matters. I think very profound statement. You could have also said judges matter. It's related. And you also talked about the shift, that the interest should shift not from how many people attended, but to the question, did it improve competency? And moving into measuring. And as you concluded, again, very profound assertions you made. You said the environmental challenges will not disappear in the coming years or soon, if ever. But the question is whether are we prepared to meet those challenges? Yes. I often say that judges are a function, or the quality of judgments, it's a function of what judges know. It's a function of knowledge. And you can always tell if you read a judgment. And I think that is what you spoke to. Thank you very much. Let me now move to the last speaker. Oh, two more. Okay, yes. Dr. Chandra Kanta Gwali, Senior Advocate of Supreme Court of Nepal, is going to address us on the central role of Nepal's judiciary in institutionalizing the environmental rule of law in Nepal's constitutional democracy. Thank you very much.
Thank you, Moderator. Right Honorable Chief Justices, Deputy Chief Justices, other judges, distinguished guests and panelists, ladies and gentlemen. My topic is a very long topic, just, the central role of Nepal's judiciary in institutionalizing the environmental rule of law and Nepal's constitutional democracy here. Yes, topic is long, but I have made a map. All things is included in this map, in briefly, yeah. That's why. I have mentioned here what is the environmental rule of law and key legal and institutional framework, then key environmental achievements, challenges, and way forward I have mentioned here. I want to speak in very brief. Another things, I have also made, or I have also drawn some thematic concept also. I will focus on mainly what are the legal provisions in Nepal, what are the independence of the institution of as a judiciary, and major international declaration. Then lastly, I will focus on landmark decision which are done by Supreme Court of Nepal. This is my will be a presentation, yeah? When we talk about the environmental rule of law, it emerges as a foundational principle of modern environmental governance. It transforms environmental protection from a mere policy objective into a legally enforceable obligations supported by constitutional rights, effective institutions, judicial oversight, and access to justice. Another think just, global warming. When we talk about the global warming, it is a behind of a rapidly industrialization and around the world, even around the world, just, armed conflict, the use and production of hazard chemicals, deforestation, biodiversity loss, and the excessive use of plastic have significantly increased pressure on the global environment and contributed to climate change and global warming. Climate change is now one of the most significant challenges facing humanity. Rising global temperature are disrupting to weather patterns and seasonal cycles, increasing the frequency, intensity of extreme weather events, accelerating sea level rise, melting glacier and polar ice, increasing forest fires, and threatening ecosystem and biodiversity. These impacts are particularly severe in vulnerable regions, including the Himalayas of Nepal, where rapid glacier and snow melt pose serious risks to water security, agriculture, ecosystem, and communities. When we talk about its consequences, are distributed equally, just, farmer, indigenous peoples, coastal communities, developing countries like Nepal, and other vulnerable populations often bear a disproportionate share of the environmental and economic impacts, despite having contributed comparatively less to global emissions. That's why we need to implement and institutionalizing to the environmental rule of law. Environmental rule of law, when we talk about in global perspective, there must be a provision or must be law or institution should be independence, enforcement law or policy. There must be judicial rights or sustainable justice, sustainable development. That's why, in a sense, environmental rule of law means that no person, institution or government is above environmental law, and that environmental governance is guided by legality, accountability, justice, participation, and sustainability. This is the important thing, I think. There are so many principles the UN also has guided, or there are so many conventions. Nepal is a party also. I think there are two types of procedures. So we have first one is related to the substantial right. Then another right is procedural. Without substantial right, we can't, if there is no procedural right, we can't execute the environmental rule of law. That's why I have mentioned here two types of rights. Number one is substantive dimensions. There are so many: sustainable development, precautionary principle, prevention principle, polluters pay principles, intergenerational equity, public trust doctrine, ecosystem, integration principle, principle of ecological integrity, principle of resilience. It is very important for us, like Nepal. Principle of environmental justice. Then another procedure law should be exist among this procedural environmental rule of law. Public participation is a must. Access to environmental information, access to judicial and administrative remedy, free, fair, and informed consent, consent for the indigenous peoples, fair hearing, natural justice, burden of proof, effective remedies, social justice. These are the main procedural environmental rule of law. Nepal is a party to around 3 dozen international environmental conventions, obligations, and protocols addressing biodiversity, climate change, forest conservation, wetlands, hazard, West Protected Area and related. We are 32 convention. Nepal has a party, is a party. These 32 convention or protocol or obligation. On this obligation, while making constitution in Nepal in 2015, at that time, the Constituent Assembly requested me, please write a article which is included in fundamental rights. Then I wrote a draft and I submitted a draft in the Constituent Assembly. Then Constituent Assembly ratified that article. I wrote on the basis of these conventions. Nepal is party 32 conventions or protocols. Then on the basis of these protocol or conventions, I wrote a draft for the article of fundamental rights. Then the Constituent Assembly ratified that articles in the Constitution of Nepal 2015. It was promulgated by the Constituent Assembly in Nepal. We have a constitution and there are so many policies or acts and bylaws also. These I have mentioned here. When we talk about the constitution, just I wrote that articles under Article 30, right to clean environment. This article I had an opportunity to write as a constitutional expert of Nepal. It is included under the Article 30. It is envisaged that every citizen shall have the right to live in clean and healthy environment. The victims shall have the right to obtain compensation in accordance with law for any damage caused by environmental pollution and degradation. This article shall not be deemed to prevent the making of necessary legal provisions for proper balance between environment and development in development works of the nation. This article is a fundamental rights of Nepal. It is under Article 30. Then, on the basis of this article, we have so many laws and policy have been promulgated here. This Environment Protection Act is under the Article 30. And we have also highest peak of mountain, just called the Mount Everest. We have then another, we should environmental conservation of Everest. There is a raised the question that at that time we filed a writ petition in the Supreme Court, and the Supreme Court continuous mandamus to preserve the Mount Everest. That is a contribution by me also. Then another law is related to the Endangered Species Wild Fauna and Flora Act. We have promulgated. Forest Act. We have this tree. Look, you can look this. This is 300 years. Now this means the tree means called Sati Sal. It is a very endangered tree. There are 300 endangered trees, like a niche god. We will be build up international airport on this area. We protected these trees. That's why. And National Parks and Wildlife Conservation Act, the wildlife mentioned is Schedule 1, shall be considered as protected wildlife under this act, which include the mammals. We have mammals, yeah. Red monkey, salak, wolf, Hular, black tiger, leopard, tiger, wild elephant, rhinos, subspecies, musk deer, wild beast, orna, kishnasar, birds, dafe. Dafe is the national birds of Nepal, yeah. a moral camera, big dhanish, reptile, crocodile, golden gopher. Yeah, these are the our endangered mammals or birds. Yes, we have a constitution or laws and policy, but each and every government breaches policy, even policy, not only policy, constitution also, and laws at that time on the basis of Article 103, 1 to 3, inconsistency with the constitution. If laws are promulgated with the inconsistency with the constitution, at that time any citizens can file the writ petition in the Supreme Court as a public litigant or public litigation, and mandamus statutory prohibition, habeas corpus, where environmental issues intersect with the unlawful detention and right violation. Interim and injunction is relief. Also, we have filed the writ petition. Then judicial review, administrative and government decisions, compensation, restoration, or legally available, continuing mandamus and judicial. Then another, I will focus on I have already told you, I have selected 7 cases here, just selected decisions of the Supreme Court relating to the environmental rights, sustainable development, forest, protected areas, environmental impact assessment, public interest litigation. There are 7 cases as done by the Supreme Court, issued a mandamus. These cases are landmark cases in Nepal. Yeah? I will present shortly, very shortly. Yeah? This is Bond Supreme Court Nepal in the movement in Gen Z. Do you hear about the Gen Z? Gen Z movement in Nepal. Now the government is Gen Z government. Yeah. This case is very important for us. The case was Advocate Shailendra Prasad Ambedkar versus government Nepal. The fact was the petitioner challenged the government's decision to amend the Chure Trai Modest Conservation and Management Master Plan through budget ordinance, thereby permitting extraction stone, sand, and gravel from this area. The Supreme Court of Nepal applied the environmental rule of law, sustainable development, precautionary principle, intergenerational equity, and constitutional right and clean, healthy environment. The Supreme Court of Nepal held that environmental protection cannot be weakened through executive and legislative measure and development. Then another case was Prakashmani Sharma. It is related 20 meters from the corridor of a river. It is a continuous mandamus by the Supreme Court. Then another, just 3 cases, yeah, I will mention. I have, yeah. Time is finished? Oh, I see. Just Surya Dungal, I look, Godavari Marble Dana, yeah, ratio this one, and Dr. Nia, importance this one, and Dilraj Khanal, the sustainable development, precautionary, yeah. Then another one, just one, yeah, India. I have mentioned just there are so many challenges and major findings and conclusion also. You look at the website and yeah, thank you.
I apologize for the lack of time, but you did traverse the essential features of your paper, the legal framework, the constitutional and legal framework, the leading cases, and asserted the essence of the rule of law, that no person or a government is above the law. So I'll move swiftly to the next speaker, Mr. Solomon Yeo, PCO, founder of the Pacific Islands Students Fighting Climate Change, PhD candidate at Waka Victoria University in Wellington, New Zealand. Is going to speak to us from Pacific to the World, how a student and government-led campaign have transformed international and global climate law. Mr. Yeo, the opportunity is yours.
Some really nice handwriting here on this book. Thank you. Right. All protocols observed, but the Solomon Island in me have to say and acknowledge all people of bless, yeah? Yesterday, Chief Justice talking about that Papua New Guinea is richly blessed. And I think that blessing is your people, who after 50,000 years of civilization and still living has resulted in the largely intact environment that we see today and enjoy in Papua New Guinea. And it says a lot about the people, Loples, Loasples. And while I echo the late great Justice Bernard Narakobi, that while we are new to the institutions of today, we are not new to humanity. Yeah. So as 15 minutes goes, I'm going to summarize 7 years of work in 15 minutes. I'll do my best. But I would like to tell it in a very Pacific way, in a way that we say things in the Pacific, which is through stories. And this is a human story, because behind every pen, every word, every voice uttered is a human being. And lo custom nova lo East Are, we have this word called hikua, which means relationship. But any Pacific Islander here today would know that it's more than relationship. It is a way of life. And I also would love to really put this on the pedestal, because we have to acknowledge the Republic of Vanuatu, because not only their government, but their people as well have led to this incredible achievement of humanity and human civilizations around the world. And today, I speak to you from a standpoint of a Solomon Islander. And as my good Wantok has reminded me, putumimi antap. So I will do that today. So this is a story of a rivet and flowing and merging into the confluence of the Pacific discourse that ultimately flows into the great One Solwara, or the ocean that is humanity. I will say this acronym a lot, but the International Court of Justice, AO, or Advisory Opinion, or as we call it in the campaigning days, ICJ AO campaign. And I refer to we, as in our Pacific Island students fighting climate change, as a group, and myself, I, and as in myself and I. So, and thank you to mas Wantok Hilan for these slides. Thank you to mas for putting it up there. Our story actually begins in the United Nations General Assembly on the 38th session, the 14th plenary. There was a man representing a newly independent nation of Vanuatu who went up to the podium and said, let our children, let our children decide the future, but let us ensure that there will be a future for our children. And that person is the first Prime Minister of Vanuatu, Father Walter Haid-Lini. And decades later, that same thinking or that thought came into the heart of a small group of law students at the University of the South Pacific. So some may know this, but this is the entrance of our MLS campus at Vanuatu. And in that time, we were doing international environmental law classes, and many of us were really disappointed about, after the 20 plus years of negotiating climate change, we have not really moved that far. And a professor said, would you like to do something about it? It's like, yeah, why not? What do we have to lose? But what will we lose if we not do anything about it? So all of our students gathered, we did a lot of research into it, and there was a lot of options that we had, but as our good colleagues from Samoa and Tonga has said, let's choose the most ambitious one. So we got the International Court of Justice Advisory Opinion, but in that time, people, even our classmates thought we were crazy to do this initiative. But we decided that it has to be done because the law says it, the world needs it, the negotiation needs it very dearly. So we decided on that matter. So it was really not we didn't get any points for this. It was just an extracurricular activity that some of our students were passionate to do about it. I would like to rope us back in. This is my own philosophy in the way I see how this campaign went about. And there are many, but I just draw on these two important ones. The first one is Q bono, which is Latin for who benefits. So this was said by the famous Cicero of the Western worlds. But this quote really reminds me of when I was doing my research back to this individual called Fyodor Martens, as many of you who took on international humanitarian law would know as the Martens Clause. So back in 1900s, the governments of the world have to meet because they were going to go into World War I. And then, of course, the technology of the time was so devastating in terms of how we could inflict damage to human lives. And then there was a clause that says we should not just define humanitarian law or the duty of states towards whether civilians should also be protected under international law and under wars of conduct. And then Martins said, Q bono, who benefits from the ambiguity of the law? Does the small states or the small people, do they get richer or they get powerful? I'm paraphrasing here, by the way. Or whoever is conducting the rules of war is the true benefits. So I think that comes back, as I will later mention in my conclusion about that. Same question applies to climate change. And the other is this incredible justice from a former vice president of the International Court of Justice, Christopher Weramantry. And I was doing a research and reading all of his separate opinions, like, this man is so human. He understands human civilization, which in his Gapsikovo and Nagemura's case, he drew on the knowledge of all civilization across the world and really challenged the word international in the International Court of Justice. Is the International Court of Justice truly international, or is it just built on strongly relying and still relying on Judeo-Christian values and thought? What about the Pacific? What about Melanesia? So it really inspired me that this person was really challenged in the court at that time too. So this comes back to our story, which lo Vanuatu, lo Bislama, and se storian, which means story. And Blong Yumi is our story. Yumi is Yumi, we. So it's our story, actually. And this story is not just by the students, but the hard efforts of civil society, even to the cleaners who helped us and said, we really want to support your initiative. Everybody, people of Pacific, we worked behind this, day in, day night. Not saying that metaphorically, but really we did work day in, day night on this. And this is the campus that we have. This was actually the launch that we did back in 2019. And, that's a little bit messed up, but the question was really, that concerned us a lot, that we want to ask the court was, does nation states have a duty and a legal obligation to protect the rights of the current and future generation against the adverse effects of climate change? We were concerned not only for us, but our children who will inherit this planet after we leave. So it was an intergenerational equity question that was the foundational and underpin why we did it in the first place. This is, I have to really mention this individual. Some of you might know him as the Honorable Ralph Reagan Vanu. In 2019, he was the Minister of Foreign Affairs in Vanuatu. And we sent letters to all governments in the Pacific, as that was a target. No one responded positively. Only the Vanuatu government. And it was Honorable Ralph, who really invited us or accepted our invitation to go meet him. So that was the day when some of our classmates, we went to meet him. And then we thought we had to explain for like 30 minutes or an hour about why we want to do this. In just 1 or 2 minutes, he just said, great, let's do it. And that's how it began from the government perspective. And Honorable Ralph, with his government, took the initiative to the Pacific Island Forum that was in Funafuti in Tuvalu back in 2019. And it was really hard at that time too. There were a lot of interest at play and geopolitics, etc., etc. But we did got it into the paragraph of the final communique. But the leaders then just noted it, which is, to us, many of us, we thought that was a win. Hey, at least we got it into the communique. But then, of course, the true bosses behind the campaign are Samoan and Tongan law students. They said, no, we must achieve this. We must get it until the end. So we persevered. This is just, I believe it's the second campaign strategy that we built. It was just, this of course developed into more complex, but it was really just to target a grouping. So starting from Pacific Island Forum, we saw that it can lead to other international grouping that is out there, and through a grouping-based approach, we'll be able to convince and get the advisory opinion to the United Nations General Assembly. But, of course, there is another part of the story that made it possible. It was the alliance of a climate justice advisory opinion, as we call it, of civil society, 1,500 civil society across the world. They came together and said, we want to support your initiative. And the way we got them was we just told them about who we care about, which is ourselves and our children and the future of this world. And they said, we too, me too, or we too. So we all joined together to form this great alliance. And man, did we pushed a lot of barriers ahead. But then it was just this alliance and Vanuatu government, and not a lot of Pacific as well as the rest of the world really supported that initiative. And until we had to go through the campaigning, we brought it to New York, which I have to highlight as really a humble mission. There's only like 4 of us in reality who was full-time there working. This is of course many, but these are the president of Vanuatu visiting with this delegation. And I also would like to highlight the secretary, Evelyn Adams, on the lower left, who really not only worked as a secretary, but did everything, actually. So, in great honor and privilege to them, to work side by side with them. And the linchpin in the New York phase campaign was Ambassador Odo Tevi and Ambassador Lucero from Samoa. They worked hand in hand because Samoa then was the Small Island Pacific States chair. So together with that mission, we worked with all of the Pacific mission to reach out and build on the networks to get the mission states on board. And finally, it was not the Pacific Island Forum, but the Pacific, Caribbean, and African organization that endorsed the initiative first. So really kudos to them, and they stood by us during the resolution phase. And even though the legal process was going, the civil society movements and across the world were really campaigning behind. The photos here you see, they actually happened, and it was all from individuals volunteering their time. The left is that's in Suva. A lot of our friends there campaigned for the initiative. We did a small flotilla, as you've seen in the first slide. It was really a concerted effort of citizens, government working together hand in hand. We also say it in the river close to the UN, everything. The real time came at Sharm el-Sheikh in COP27 in Egypt. There, the government of Vanuatu has formed this thing they call the core group, which is a blend of developing countries and developed nations, which, according to my ambassador, he said, that is the solution to climate change, multilateralism. There cannot be us and them. It has to be us. It has to be Yumi. So we kept that spirit until the end. And of course, some of the lawyers behind the scenes are people saying, we have to kick out Germany because they want to water down the text or change a lot of things of the text. And then Ambassador said, no, we have to keep it on. And really, Honorable Ralph Reagan-Vano came in at a clutch because he said, we have to listen to the New York mission. because they know best and how to pass a resolution. And we went forward with that. We kept most of the text in it, and of course, that text led to the resolution we saw today. And anyone who studied or understand International Court of Justice advisory opinion is that you never ask a question that you don't know to the International Court of Justice. So it was well thought and well worked out, yes. And a good colleague, Nina, highlighted yesterday about the rulings. I will not touch on that, but just to underline a key point was that 1.5, the principle of 1.5 that Pacific Island countries has been advocating for it's now an international law. And finally, the full circle of the adoption day, which has just happened this year actually, they endorsed it. And I would just like to finally close by saying, going back to the story of how we got our statement into the ICJ. As Wantok Bal has highlighted yesterday, Cynthia, but behind Cynthia was this group of men, but not men as in the gender, but the men who really understand the people of East Areare. All of these are chiefs, and they really helped us understand. We draft the text of what Cynthia has presented, because Cynthia is also from that area. But at the core of it, we spent 3 days and 3 nights, literally 3 days and 3 nights, talking about the cosmic view of life of the people of Areare, and that's what we got into the court. So we did contribute to that point. In conclusion, I just want to refer to a quote that always stuck in my mind as we're doing the story, in this work that we do, is that the world is really not made out of atoms for the scientific people. It's not made out of atoms, but it's really made out of stories. And to that end, I just want to refer, coming back to the whole journey as a whole, I would like to thank each and every one of our Pacific Islanders who have worked hard and beyond with this to make this story possible. And that's it. Big fala tage tumas.
Yes. Another round of applause. Again, I must apologize. I realize that the designers of this program, there was 6 speakers for this session compared to 4 or 5 for other sessions, but allocated the same time. So if they were pressured for time, they must blame the design, not the moderator. But very profound statement coming out of Mr. Yeo. I have no time because I think circumstances have collided, colluded with lunchtime to totally nullify any prospect of allowing any questions. But certain things that I would want to, I think other than the content, what was touching, speaking for myself, other than content is how you acknowledge everybody who was part of the journey. You said, from cleaners, you went up to professors, government ministers, communities, chiefs, everyone. I think for me that was quite humbling, that it was such a collective effort that now and then you'll return to acknowledge them. I think that was profound. And in reference to the deputy, I nearly said the deputy chief justice, but the deputy president of the ICJ, you said, wow, this man is so human. And yes, judges are human and have hearts. So it does seem we are on the right track in that sense. And one other last quote, I don't know who you attributed to, but someone said, let's ensure there will be a future for our children. And under short assertions, someone says, I think a government minister says, let's do it. And the professor said, would you like to do something about it? Very profound, so forth. So let's give a round of applause to all the speakers. Let us hope that all that they say today will ripple like rivers and carry justice across all our shores. And all the wisdom that resonated today will stay within these four walls and motivate us in the time to come. Thank you so much. I have determined that there shall be no questions given the lunch, and it is a pronouncement without an appeal. Accordingly, you will bear with me. I think I should discharge you for lunch. Yes, there are, okay, some gifts to the speakers. Thank you so much, distinguished panelists. Thank you so much, distinguished participants. Lunch is upon us. This meeting is adjourned.
lunch on the second day, well actually it's the third day, isn't it, of the LAWASIA Conference here in beautiful Port Moresby. I sincerely hope you've been enjoying your time here in Papua New Guinea and that you'll have an opportunity to see some of the sights of this wonderful city of Port Moresby. If not, I hope you may be inspired to return to enjoy PNG hospitality and sights at a future date. So my name is Berna Collier. I'm a judge of the Supreme and National Courts of Papua New Guinea and also of the Federal Court of Australia. As you can see from the program, my co-moderator is my judicial colleague, Her Honour Justice Larissa Andelman of the Supreme and National Courts of Papua New Guinea. We have the honour of moderating this session, the theme of which is environmental dispute resolution. Now, many of us here are judges. We understand and adjudicate hearings within the environs of the courtroom. In PNG, however, the courts recognise ADR as a key tool in resolution of litigation before it. You all heard Deputy Chief Justice Kandakazi last night when His Honour anticipated the establishment of a Pacific ADR Centre. There is a possibility we in PNG will all be watching with great interest and enthusiasm. Relevantly to the present topic before us, it is clear that modes of alternative dispute resolution, particularly in the context of transnational disputes, are a common and often very effective tool the parties may, or option the parties may take in seeking to address and resolve environmental disputes, rather than the conventional approach of litigation in the courts. Today, we now have 5 eminent speakers who will be addressing us on the topic of environmental dispute resolution, but from different perspectives. Noting the importance of each speaker having a proper opportunity to make their presentations, and also recognising the probability that some of you will have questions, our speakers have agreed to limit their presentations to 15 minutes, and also to Justice Andelman and I just giving very short, you did say 15 minutes? Yes. Good. Very short biographical details in our introductions. So without further ado, I would like to introduce our first speaker, Ms. Deborah Lockhart. Ms. Lockhart is the Chief Executive Officer of the Australian Disputes Centre in Sydney, a role she has had since 2013. The further details of her very impressive resume are in the materials. Ms. Lockhart's presentation is Beyond the Western Lens, Adopting ADR for Environmental Justice in the Pacific, the ADC Partnership Process. Can you please join me in welcoming Ms. Lockhart?
Lovely, thank you. Let me get that there. Chief Justice, other distinguished judiciary, ladies and gentlemen. Evan Trul Olgeta. Unstap Orat. Welcome and hello, and good afternoon. It is post-lunch on Friday, and you do know that statistically, at least one of us is not going to make it through the afternoon without nodding off. So let me start you off with a shot of what I call conference caffeine, a critical question. How can we adapt ADR for environmental justice in the Pacific? To move ADR beyond the Western lens and respect local customs, what we call the Pacific Way, I introduce for your consideration the ADC Partnership Process. This analytical framework was originally developed by the Australian Disputes Centre in research first presented to the Australian oil and gas industry, and it's since been used in diverse areas such as evaluating land claim mediations in Cambodia. By framing the form of the forum, focusing on the key procedural domains that are essential to private dispute resolution and remaining flexible in their application, we can transform adversarial environmental fusses into more collaborative, ecologically just and legally sound resolutions. Over the past 50 years, climate-borne issues have increasingly threatened the Pacific. We see these real and present risks experienced daily by communities region-wide. As discussed throughout the conference, a central challenge for environmental law is the sheer scope of these disputes. They really sit neatly in one category. Rather, they cross disciplines, boundaries, and jurisdictions. They involve complex scientific data and often dozens of distinct parties. As these conflicts proliferate, ADR has a vital role to play, not merely as an efficient alternative to litigation, but as an appropriate, flexible and relational process. At its best, ADR is about self-determination, keeping parties in the driving seat so they can resolve their issues themselves. For the people of the Pacific, its true promise, it lies in its capacity to create processes that are culturally appropriate, trusted and capable of protecting long-term relationships. The Australian Disputes Centre designed the ADC partnership process not as a rigid manual, but as a fluid framework structured under 3 interdependent domains: authority, decision-making and collaboration. It is multidisciplinary in design and draws inspiration from Western and Indigenous consensus-building models, including a traditional Zulu model called Indaba. Indaba was the process that was deployed at COP21 in Paris to break decades of deadlock and deliver the most significant geopolitical accord of our time, perhaps all time, the Paris Climate Agreement. As we prepare for COP31 and major preparatory forums in the Pacific, a diplomatic methodology is more critical than ever. COP31 will focus on turning global communities into practical, localised outcomes. By anchoring our Pacific environmental disputes in the ADC partnership process, we can apply a proven process that has been fired in the ancient fires of Southern Africa and the fires of international diplomacy. Each domain of the partnership process is a vital diagnostic tool throughout an ADR process. Under authority, we ask, do the parties' negotiating representatives have full authority to bind their community? Is the process visible to all stakeholders? And focusing on the dual engines of ADR, straight talking and deep listening, are people free to speak openly about their concerns? Under decision-making, we focus on how progress is achieved. The framework steers parties away from the rigid positions and towards interest-based negotiations. It encourages creative options while maintaining clear, well-defined red lines to efficiently progress discussions without compromising the parties' core values. Under collaboration, we ask, has adequate time been given for the parties to prepare, think, and distill the information and the options before them? Has respect been shown to everyone's input? And are we actively searching for mutually beneficial outcomes that protect long-term vital relationships? The ADC partnership process prioritises building enduring, respectful relationships, understanding that trust is built in many small moments, not one grand gesture. The framework highlights 5 core pillars for building that baseline trust: straight talking, deep listening, time, respect, and visibility. Of these, we recognise visibility as the golden key. Closed-door negotiations can breed suspicion, including in customary cultures. If negotiators vanish behind a door and return with a finished deal, the community may instinctively reject it, destroying any legal standing or social durability. Visibility does not mean abandoning confidentiality altogether. It means designing practical communication protocols so the process is seen as legitimate, such as silent observers, live video links that were used in Paris, and community report back protocols. In designing for structured visibility, we provide the foundations for trust. And in environmental disputes, trust is not a soft option. It is the condition on which durable outcomes depend. Crucially, the partnership process allows us to build a theoretical bridge between the Pacific tradition and Western ADR. When we examine the sub-elements of the partnership process, we can see they are central to the classic Western Harvard model of negotiation and mediation. Core elements of the Harvard model include separating the people from the problem, focusing on interests rather than positions, generating options for mutual gain, and preserving relationships. You would recognise these elements in the building blocks of Pacific processes. For millennia, Indigenous dispute resolution processes have utilised these principles. Thus, we see many elements of the Western model of mediation as a contemporary take on the relational and restorative systems that have governed the Pacific for thousands of years. By establishing this connection, we can see how to adapt the Western ADR processes within environmental law. Take two ADR processes. We know that Western commercial mediations and expert determinations often prioritise transactional speed and detached neutrality that can alienate Pacific communities. To adapt mediation, our pacing must shift from artificial deadlines to culturally appropriate timelines, allowing for communal consultation that is required in any given situation. In a conventional Western mediation, absolute confidentiality is treated as essential. Only the parties and their lawyers are generally in the room, and what they say there stays there. But in many Pacific contexts, that same confidentiality can actively work against trust. Structured visibility protocols allow the community to perceive the process as fair. Negotiators sitting within a wider circle of stakeholders, so accountability is physically present in the room, or pausing negotiations so the agreed representatives can report back to the village before the next stage of negotiations are undertaken or a binding agreement is signed. Similarly, expert determination can flex and evolve. Instead of a desktop review by an outside technician, we introduce procedural flexibility to pair Western scientific data with traditional ecological knowledge, or tech, to provide continuous multi-generational observations over decades or centuries. In Vanuatu, chiefs determine customary land boundaries by interpreting Kaestom, traditional culture and custom, oral histories and genealogy. In Kiribati, the Unimwane, the community leaders, determine customary fishing rights collectively through generations of accumulated knowledge. In Samoa, the Matai, the chiefs, resolve questions of genealogy to assist broader environmental disputes. Rather than replacing Western expertise, these examples demonstrate how expert determination can recognise tech alongside scientific evidence. For example, if an expert must determine whether an infrastructure project caused a sudden drop in the river's quality or fish stocks, Western data may completely lack a baseline from 30 or 40 years ago. Tech can fill this void by providing the precise historical baseline of the river's health, flow, and seasonal behaviour across generations. It fills the blind spots of modern science. By melding hard science with ancestral data, the expert's determination shifts from a top-down mandate to a technically precise, culturally safe, and socially accepted outcome. Framing one mechanism to make this adaptation possible is procedural flexibility by framing the form of the forum to fit the particular environmental dispute. In practical terms, we can adapt the venue, the evidence, the authority structure. For example, with adapting the venue by moving the process closer to the land or water in dispute, that shift matters. It gives parties, regulators, companies, experts and the community representatives direct exposure to the physical and ecological reality of the conflict. It creates instant visibility and transparency. We can expand the depth and quality of evidence by also recognising storytelling and oral history as a meaningful source of knowledge. Allowing community members to speak through narrative does more than provide information. It creates space for people to express concerns, explain relationships to place, and articulate interests that may never appear in technical reports. Storytelling also slows the process down in a highly productive way. It gives time for reflection and enables parties to identify creative options that may otherwise be missed. In this way, site visits and storytelling satisfy both Western principles and the ADC partnership process domains. They bring interest to the surface and deepen understanding, and create the conditions for solutions that are both practical and credible. We can also adjust the hierarchy in the room by recognising the role of elders, chiefs, and customary leaders. In standard Western disputes, we often assume that the individual representative has authority to negotiate and settle, treating authority as a matter of appointment or instruction or power of attorney. But in Pacific communities, authority is relational. Elders and chiefs carry obligations not only to current community members, but also to ancestors, future generations, and the environment itself. The partnership process therefore asks at the outset, do these people in the room truly have authority? Including elders and customary leaders helps answer that question and creates a culturally safer structure for straight talking and deep listening. Importantly, this does not mean replacing legal representatives and technical experts. It means delivering a process in which customary authority can operate, allowing time for community caucuses, private reflections, and village consultation. When an outcome is reached through that structure, it is far more likely to carry social legitimacy. And that legitimacy matters because without it, even a legally binding agreement may fail in practice. These adaptations are not cosmetic. They go to the heart of the process, helping us answer the core diagnostic questions of the partnership process. Who has authority? How were decisions made? And how can collaboration be sustained? In conclusion, actually, we might just go back there for the conclusion. Environmental conflicts in the Pacific are not abstract legal technicalities to be solved with transactional Western playbooks. They are deeply human crises that impact livelihoods, customary land, ancestral waters, and collective identities. The ADC partnership process offers a framework that doesn't abandon the